I was seeing voicing my around until you turned around. I said, what is voicing doing here?
A couple of times, journalists come and say, so the hard one together, now you get and then briefing there's
no one you took it. That's why
Can I just, I would like to put this here. Thank you very much.
Yes.
It's a mic for the recording for television.
we whisper to one another.
No, but then you will be talking back there, right? And now we want.
It happened in Pretoria there.
Oh, really?
Yeah.
No, hopefully it won't.
They're even listening to what the judges are saying.
I've sent it now. Got it. I told you because but just no, of course.
Als is twee vandaag.
Yeah. You can. But it doesn't look right. It doesn't look right. If you look at it from an aesthetic perspective. Good morning, how are you?
You don't have a wardrobe?
Space. Spread
it out a little bit. That might be in the interest of justice, I don't know. Hello James, how are you? Nice to see you. How are things going? Fairly busy, as you can see. Hello, how are you? Nice to see you too. Nice to meet you. On different sides, yeah. Yeah, so the pupillage is not in the end, so now I have been unleashed onto the unsuspecting public. Well, I was teasing Elsie about that during the week, so yeah. Hopefully. Indeed, they can withstand more pressure. Anyway, thanks so much to you too. I think
Hey, how are you doing? Doris told me you're coming here.
You almost just wanted to sit like that.
no, definitely not. In Natal? Well, no, I lost out because of the proportional allocation of votes. I missed out by a few But remember, it's on a PR basis, so after they allocated the votes to seats using the ratio, I needed fewer than 1,000 more to be elected.
None of it much work.
And so I was short 800 or something. But you see, the small mass is not as if I had been successful with that, and I think that was scholarship. I think it will work out well. I'm here.
Branding was
That will be the best. Landing on another deputy singer right in the back.
branding was
Usually likes to be flat.
Where do I go?
Very funny. Can't stay away from the sun. Unless
for you down here. Hi.
Last time I said it was James.
Yeah, yes. Different now. I'm fine as you.
Oh, good, thanks.
One of the proposals was that. How are we going to arrange it? Yeah, the difficulty is we've got 4 of us. The Amicus need to also sit in the front. The juniors. Anton likes to reflect. So they're 4. Okay? There's 4 of us.
Camille, nice to meet you. Yeah. What's that? I've got it electronically. Yeah, I do.
Yeah. Oh, you're together.
For the politics, you could never sit in the job. Beyond reproach, beyond reproach.
Good to see you, yeah.
Something about keeping constancies down. okay taking a note? Thanks.
Supposed to move the mic. Because there's another piece of paper that he wants on there as well. That he wants left. So if you can leave it like this.
Michael, both you and Janice have previous to that.
So in the disciplinary review matter, it's just Jana.
Okay.
In the other matter, it's me and
Okay, great. Thanks. Thanks.
So here you want to come and donate your funds to the LRC?
Yeah, potentially. I mean, I don't know what I'm getting myself into.
MCUMISA. MOC.
Oh, Umbiso.
Yeah,
Oh, sorry.
MCUMISA.
Yes, great. Yeah, potentially. I don't know. You know, my position is that I have volunteered my services to a few NGOs in which I have personal connections. But then other than that, oh, right. And Steph, I think they're going to see the judge.
information. And there, yeah. Somewhere else. And I forgot something else. Like the chair. What that chair you make it put here? That chair. And we put it here. We put the box in the chair. This box broken. No, leave it for me. No, lift it up. Let's put it back on there. Put it back on there. Yeah, but put it back on there. And Judge, the fancy stuff's that side, like that. I'm going to ask you. Yes. I want to put the files on it. Let me ask you. I did ask about the chair and then she said, also putting these dialogue that isn't because Judge said they must start the main application first.
My judge, I don't know what the application is. What you mean?
So the main files are here now. So make sure that the main files are in these main sites and then the review application.
My judge just put the stuff that was
I think it might just be in his way, don't you think? I think it's within the box.
on top here. I wonder if we should just, because there's probably enough space for it.
You see, this is easy within his reach. I think leave it in the box.
Yeah, let me get it.
Is it falling apart? Falling apart.
We're staying in this court. We have to move here. Yeah, there's no space.
The cat's back. Yeah, I'm going to sit next to the cat. I think it was just squeeze it. Just two of us are going to sit here, the other two are going to sit in front. One of us needs the control hand. So we'll squeeze up and fit in with that.
So what's the office, sorry? Yes, I've got 3 juniors, and then what I've got is my 1 junior sitting next to me. But thank you, I accept it. Yes. Sorry,
I was going to see
may I make a suggestion? Are you going to sit by yourself here? Michael, because once we finish with your amicus, then you can go.
come on. I'm listening to you. Just bear with me, please.
I'm just going to... Yeah? I don't is I appear in case number 18107616 with Ms. Magosi and Mr. Bishop, and in the other case number with Ms. Blizo.
Thank you, Mr. Katz.
Please the court, my lords, I appear for the public protector in both applications together with Mr. Stubbs.
Thank you.
May it please you, my lord, I appear with my learned friend, Mr. Premid, for the SABC in both applications.
Thank you.
May it please the court, I appear for the Minister of Communications in both applications together with my learned friend, Mr. Patel.
Thank you, Mr. Mankey.
Please the court, my lords. Together with Mr. Ayayi, I appear for Mr. Motsoeneng.
Thank you, Mr. Bester.
Please the court, please. My lords, I appear for IMPRA, Independent Music Performance Association. We wish to the admitted residents and Amicus. With me, Mr. Junior, but I don't see him in United States.
Where's your junior?
Mr. Mofokeng.
Mr. Mofokeng, is he not present?
He was present, maybe he went out of court.
That's good. Who else do we have? Mr. Mopsi?
May it please the court, Your Worship, I'm appearing for the Decolonization Foundation seeking an application as Amicus. I am appearing with my junior, Advocate Masebe.
Thank you so much.
Mr. Gordon, I appear for the Musicians Association of Africa.
Hmm?
And also the application to the
What association?
Musicians Association.
Musicians Association.
My lord, I have an application which will back lift to hand to your lordship. I understand your lordship have not have sight of the application itself with leave of court. May I hand the application?
Yes. Was that served on all the other parties?
I have copies which I will immediately now distribute to all the parties.
So you haven't served this on all the other parties yet?
My lord, it was a bit late that whether it was yesterday. We have not as yet. It was emailed to all the parties yesterday. I believe it was in the afternoon of yesterday, which they could not have received due to the coming to court. But we have at least hard copies which we will distribute to all the parties now.
Is that all?
That's all. Thank you.
Well, in terms of the other Amicus, where are your papers? I see you looking around. Where are your papers?
My understanding is that the papers will be emailed to the other parties. I don't have
No,
that
but
copy.
was the paper served on the court?
Not yet.
Now, why are you here if you haven't served papers yet? And you want to be admitted as a friend of the school?
I know that the papers are ready to be served. May I speak in that?
But is this normal procedure where an amicus wants to be admitted as a friend of the school, hasn't filed any papers, hasn't filed papers to the court, and you want to be admitted as a friend of the court?
Are you to ask that these proceedings be adjourned?
May I ask for a 5 minutes indulgence? I don't know what happened to my attendees along the way from the hotel to here.
But are you going to ask that the proceedings be adjourned if you'll be allowed in as an amicus, in order for you to present evidence which the other side can answer, or are you just wanting to make submissions?
I just want to make submissions.
Okay. Well, it appears that there are 3 groups that want to join us amicus to the court. We will first would like to hear the application and deal with that, subject to what the other parties have to say. Mr. Katz?
Yes. My lord, the Democratic Alliance objects to all 3 parties trying to come in. And I use those words because we've only seen one formal application. But to the extent that there are 3 applications, the Democratic Alliance says that all 3 should be dismissed, that an appropriate order as to costs, and perhaps to assist our learned friends, because the matters have been brought to this court defectively on two different grounds.
Should you not tell us that when you respond to the application?
I will do, indeed I would. But just to assist them, there was a judgment of the SCA in May, which I will beg leave to hand up the relevant passage. But just to set out why, so that they understand what they've got to deal with from our side. They haven't complied with Rule 16A and haven't even purported to comply with Rule 16 of the High Court rules and the dicta that have been followed in respect to that rule. So that's the DA's attitude.
Thank you. Anyone else that would like to add something from the other parties? No.
We abide.
Thank you.
We abide the interventions.
The same.
Good. Well, the Decolonization Foundation, Mr. MC, you first up. Let's hear your application.
Thank you, my Lord. My Lord, I'm not going to take you through my heads. Take that the court has gone through the heads, but only to say that the decolonization is a NGO participating in the promotion of advocacy, human rights, and democracy. My Lord, I just want to go straight to the issue why we want to be admitted. I'm not going to go through everything.
Can I first ask what the implications will be if you are admitted? Because your application says that you wish to adduce evidence and you give as an example, but not necessarily all the evidence, an affidavit from a certain gentleman.
Yes.
Are you wanting to adduce more evidence?
We're not going to adduce more evidence. We're going to stand by the affidavits that we have filed. Maybe if admitted, then we shall be able to file submissions for argument at a later stage.
No, but if you admitted, are you suggesting the case is going to be postponed for that purpose?
No, my Lord, I don't want to preempt what the court is going to do. I'm just saying if we are admitted, but this matter.
But do we have your do we have the submissions you wish to make if you are admitted, or do you still have to prepare them?
We do have submissions.
Yes, but do we have them? Have
No,
you?
the court does not have them. I have the written submissions in the event we are admitted. What is before the court is the heads of argument for the application.
But within that application, there was also an affidavit filed.
Yes.
And it appears that on paragraph 7, it highlights in terms of why the applicant feels he should be admitted as a friend to this court.
Yes, sir.
If you can turn to your application and the affidavit file, paragraph 7.1, and essentially paragraph 8. Yes, and paragraph 8 of the affidavit, it's essentially advanced two major grounds why it is of the view that it could assist the court.
Yes.
If I understand correctly.
That is correct. That is correct, Madam.
But what is the fundamental ground or requirement of a person that wants to be admitted as a friend of this court? What must he do?
The fundamental ground is that that person who wants to be admitted must be able to assist the court. And to assist the court with any other information which may not have been before the court at the hearing.
Now,
in other words, to come in with additional information.
Now, it appears on the affidavit that was filed by the applicant in paragraph 7.1 and paragraph 8 advances these two grounds on which it asserts that it will be new evidence that will bring to this court. Am I correct?
That is correct. That's correct, Madam.
Now, if you turn to page 778 and 779 of the record, it appears on the very same two grounds which the applicant avers it will bring new information. Mr. Motsoeneng has already advanced those grounds.
Mr. Motsoeneng has already advanced those grounds, but those...
So has the SABC in support of Motsoeneng. Mr. Guma has also made an affidavit in which the good things that Mr. Motsoeneng has done have been set out. So, promotion of local content, champion of transformation, those matters aren't an issue in this case, but to the extent that they are, they have been said.
Yes, my
That he
lord.
was the champion of transformation, that he assisted the indigenous people, the marginalized. Those are all before us.
Yes, my lord, they have been mentioned by the other parties.
No, they were not
How-
only being mentioned, they were traversed extensively in these papers.
Indeed so. But the,
So what is new that you are bringing to this court as a friend?
but the applicant cannot or would not avoid dealing with them as well, because they go to the core of the interest groups which we are here for. The fact that there's some light that can be seen in what Mr. Motsoeneng has done. We took this part, my lord, because the DA's application says totally that this is a man who is in the darkness. This is a man who is, if I may use the word, rotten. Now, the interested group, as we represent them, wants to say to the court, he is not as bad as you allege. This is what we know of him. Even if
But
these
we have that
matters have been
information.
canvassed.
But Mr. Mse, as my learned colleagues have said, we have this information on record. We have this information not only from Mr. Motsoeneng, but from the SABC. And what is it further that they would like to tell this court, if admitted as a friend? Because we have this, and
My lord, what further the court could listen to from the
that the
applicant
Colonization
is-
Foundation might be interested in the matter and might see Mr. Motsoeneng as a champion of transformation, that's one thing, but it's totally different to admit it as a friend of the court in terms of the requirements.
My lord, Mr. Motsoeneng in his answer, as well as the other parties, they mentioned the good that he has done. We're going further than that. We're providing the court with people who are going to say this is actually what happened.
Sorry,
Via
but
those
now this is
affidavits
what I
that-
asked you at the beginning. You say people who are going to say. At the moment, we have the affidavit of one person who says that Mr. Motsoeneng is a messiah
They're just
for
in
local
Mfake
musicians or whatever. But you said you're not going to provide any more evidence.
We're not going to.
Yes, so you're not going to
But-
provide us with lots of people who share Mr. Manyu's view or the deponent to one affidavit. Now, you could go around the country and find any number of people who have this view of Mr. Motsoeneng or that view of Mr. Motsoeneng. How is it going to help the court to decide the issues in this case?
My lord, this will help the court in the sense that, as I've already indicated, Mr. Motsoeneng has mentioned it, or some other people have mentioned the good. But we say we file affidavits from those people, which then
Not from
has
those
not
people,
been done by any other party.
Not from those people, from the single gentleman who says he founded the Decolonization Foundation and one deponent. That's hardly a cornucopia of evidence.
Yes, my lord, but the founding affidavit is very extensive. It deals further with what Mr. Motsoeneng has done. Now, this is the person we are bringing forward. Number two, the affidavit of Mzwakhe Mbuli goes also further than that. What is contained in Mzwakhe Mbuli's affidavit is not contained in any of the parties answering affidavit or whatever document they filed.
Mr. Mse, did you add regard to the papers?
I did.
I've just indicated to you on page 778 to 779, paragraph 18 to 21 of that. More importantly, page 922 of the report.
Page 110?
922.
Is the court could just bear with me?
It appears a carbon copy of what Mr. Manya said in his affidavit. It's there, and it's even amplified in the papers.
I'm I'm sorry, my lord, for wasting
No,
the time.
take your
I'm
time.
still trying to get a
Take your
document.
time.
May I just be given the answers?
778 to 779, paragraphs 18 to 20 to 21.
I've seen that, my lord.
Do you see that?
I have seen that, my lord. And what is contained herein is also the ground we are trying to
Yes.
say. Yes.
Now, what's there further that you would like to add?
My lord, further to put to the court is that let the applicant be given an opportunity.
But how is it going to assist the court on deciding the issues? Because, I mean, it's here, it's in glowing terms as to how they describe Mr. Motsoeneng.
Yes, but
Champion of transformation, and are these really the issues?
But my lord, I have indicated that the affidavits that were filed say more than what is said herein.
You mean the one affidavit?
The one affidavit by Mzwake Mbuli, as well as the founding affidavit of Mr. Manye. What they are saying there, if one looks at that, is not what is contained in any of the documents. So I'm saying the area which has not been covered becomes our duty to come and cover before the court. That's the point I'm making.
Have you got anything else to say, Mr. MC?
No, my lord. Unless the lordship would like to hear on any other thing. But however, that is the case that I am putting before the court.
Okay. Yeah, no, but Council for the Musicians Association of South Africa.
The Musicians Association of South Africa,
The basis along which my learned colleague has been submitting to your lordship, essentially the basis which the musicians actually moves on the premise. The interest shown here is basically we're going further.
your lordship could look at the submissions we're making on paragraph 5, which is basically, and from the assertion that your lordship has made on the issues which were covered in the affidavits. However, we are saying there's further to that. We say now what is happening out there, in as far as the musicians association is concerned, they are now organized a whole lot of protests to indicate now the support that they're showing to the respondents, although it's actually not on submitting to lordship to say we actually support, but we to assist the court to say there is further.
But how's the protest of the musicians going to help the court determining the issues?
Actually, what does musicians?
They're entitled to protest if they would like to protest. It's got nothing to do with this court.
The basis, my lord, is the same basis that we're moving with the first with my colleagues' submissions. There isn't any further more that I can make submissions on this.
It's common cause in this case that Mr. Motsoeneng is no longer the chief operating officer and has no role to play in the content of radio. So if there's a local content requirement or policy within the SABC, it's no longer one which Mr. Motsoeneng drives, because that's not his function. The position that's of his that is now an issue is a corporate affairs function which, according to him and the SABC, doesn't involve any involvement in radio content. So why does local content, Why is it at all germane to this application? If the SABC's current people in charge of operations think it's a good idea, they'll carry on with it. If they don't, they won't. But it's got nothing to do with Motsoeneng now.
My Lord, I understand your Lordship where it gets to the point that now if the decisions at a later stage come, but now the problem now that we're faced with as the musicians is what, in as far as the local content is concerned, and the support that they are at this stage giving.
Yes, but Mr. Motsoeneng has nothing to do with local content now. He occupies a different executive position at the SABC, which is not concerned with the content of radio.
But my Lord, is still within the establishment, although I'm not aware.
Are you you, as a friend of the court, you will admit that he is still driving
I'm not sure
those issues behind the scene?
I'm not sure about that one, if he's what involvement the responsibility.
Is that the new matter you would like to bring to this court's attention, that he's driving it behind the scene?
Not at all.
Still a pleasure.
So what?
I'm not sure what the responsibilities at this stage are, but...
They're set out in the papers.
Well, then that's the end of it. If you don't know, then why are you as a friend?
My Lord, I will just stick to my... If my friends admitted, then we can be... If it's not...
So if your friend is admitted, then it's fine. If your friends don't get admitted, you're also okay with that?
My Lord, I cannot take it any further.
You can't take it any further. There's no application before us, so I assume that you've got nothing further to add. Well, let me save you from your difficult positions. Let me save you from your difficult position, because there's nothing before us, we're not going to hear you.
May I request that my application be stood down until tea time?
No, this matter is far too important. More importantly, there's a host of counsel here that's prepared for the matter, and you are not ready, and the court is not going to entertain that.
No, my Lord, we are ready. My attorney, I was with my attorney in the hotel this morning. I don't know what happened to him.
The question of being ready is not whether you know everything that you want to say. The question is whether we know it and whether your colleagues know it. And there's nothing before any of us yet.
The papers have been sent to the other respondents. It's only the court that does not take the court.
There's nothing before us, therefore we're not going to entertain your application.
But we've been here for half an hour. I've had to read overnight whether it's be 5 Rand or 20 Rand. It's a principle that where you have an abuse like this is clearly abuse. It's not a genuine attempt. My learned friend hasn't read the papers. They make no attempt, if there was an attempt at least, to comply with Rule 16A, perhaps. Not even an attempt. We have no attempt, just wasting everybody's time. Look at that. How much is this costing the taxpayer? And we're going to argue why the taxpayer in the main cases shouldn't be lumped with these costs anyway. So we would argue that these applications be dismissed with cost, as it pleases the court.
The application by the Amicus to be admitted as friends of this court is refused. Our reasons will follow, including the issue of cost.
As it pleases the court.
From a practical point of view, do the amici want to make space for others?
Yes, my learned friend asked whether it would be
May
necessary.
I be excused, my Lord? I'll speak for myself. May I be excused?
You're always welcome next time, Mr. Msi.
Thank
You're
you.
excused.
Cheers. My Lord, we have 2 applications before the court. I'm going to call the one application, that's 3104, the disciplinary proceedings application, and the other application we'll refer to as the main application. Now, although they haven't been consolidated...
Just before you start off, can we just get our papers in order here, please? Just give us a minute or two. I just want to get... Yes, you may proceed, Mr. Coates.
My Lord, there are two cases. The one case is case the number 3104 of 16. That was the case in respect of which the Democratic Alliance launched proceedings in February this year for hearing in May this year. In and during May, an application was brought to stay those proceedings by the by the SABC, and Samela J dismissed that, and now we are here before this court in respect of that application. We are at the same time not consolidated, also here for another case, which is what I'm going to call the main case, which is 18107 of 16, which is effectively to have Mr. Motsoeneng not operate at the SABC pending certain other activities. Now, what I intend to do is, despite the fact that they're not consolidated, we accept that the cases are intertwined, at least as far as remedy is concerned. So what I intend to do, on the assumption that the court has read papers and read the heads of argument, take your lordship just through a couple of the factual issues which we would like to highlight in respect of the disciplinary proceedings, without going into the remedy in respect of that case, turn to the remedial provisions of that we seek in the other main case, and then try and link the two together. I don't intend to in any detail deal with the main case's facts, other than to trawl through our learned friends for Mr. Motsoeneng and the SABC's heads of argument on that case. So now turn to the disciplinary proceedings and the file in respect of that case, and spend a little bit of time taking your lordships through that case. Why we do it is this. It seems to us that there is a concession, an acceptance by all concerned that the disciplinary proceedings were a nullity. They were invalid for various reasons. However, the difficulty that...
I don't think Mr. Motsoeneng accepts that, does he?
Well, he doesn't... Well, I'll come to that, if I may. He abides. He abides the decision, as we understand it, that was in the affidavit that he filed before the stay application. But what Mr. Aguma does, he says in his affidavit, the court will find at 585, he spends some time explaining why it is that the SABC acted in good faith in the way they dealt with that application. What he does not do is two things. One, he does not explain how it came about that Mr. Macquarie and then later on Mr. Erling were appointed chairman respectively, or how the particular pro forma prosecutors, the initiators, were appointed. And I want to come to that. And I want to flag that as item number one. Who appointed the chairperson and the initiator of Mr. Motsoeneng's disciplinary inquiry? The second thing that I want to highlight in respect of this notion of a bona fide attempt at compliance with the public protector, Skipper's judgment and the SCA's judgment is the non-dealing with Ms. Swanepoel's affidavits and why she wasn't called at those proceedings. There's absolute silence in that respect. And we want to suggest, and we do suggest, that the only conclusion the court can come to is that the disciplinary proceedings were not done bona fide. They were done with a malo fide purpose. They were done as a sham, a charade. They were farcical, and that's what this court needs to find for purposes of the remedy. I know that the court doesn't necessarily, in all circumstances, need to go into all the grounds of a challenge. But we would submit in this case, for purposes of remedy, at least, and in respect of possible appeals.
But is it essential to make that finding in terms of coming to a remedy?
Yes, I'm going to come to that. There's a case in this division. We prepared a small bundle, not very small, and there's one particular case, if we could hand up the small bundle. There's one particular case in this respect that I'd like the court to have regard to. That's a judgment in respect of... Andre, give the bundle, give it to them. It's a judgment in which the constitutional judgment of S versus Jordan was referred to for the proposition that where a court sets aside conduct, in that case it was... Yes, you can't wake up, man, wake up, man.
This bundle is also not paginated.
It's short, it's very short. The high principles that... the proposition is this. In S versus Jordan, the High Court struck down the provision of loosely called the Sexual Offences Act. It had to go on confirmation to the Constitutional Court. When it got to the Constitutional Court wasn't happy or wasn't satisfied that the particular basis upon which the legislation was struck down ought to have been confirmed. But then it was faced with the difficulty that the other grounds of attack weren't dealt with, and they were then seized with as a court of first and last instance in respect of the other grounds. In this court, Swain J, and Your Lordship, Rogers acted for the applicant in that case. But the court found that despite in that case it was the setting aside of conduct, the principles that I've articulated in Jordan, that the Constitutional Court articulated in Jordan, shouldn't apply for similar reasons to those in Jordan. For example, if the case went on appeal. So although it wasn't necessary, as Your Lordship presiding puts to me, to deal with all the grounds of attack, this court dealt it prudent and appropriate that it be dealt with in case there was a further appeal.
One will probably find as many cases where higher courts reprimand lower judges for deciding things that they didn't have to decide. I think the Jordan principle applies where one is concerned with relief claimed. You must decide enough to determine whether a particular relief should be granted. But once you've decided that a particular prayer should be granted, you don't have to decide each of 6 or 7 grounds that might be advanced in support of it. You could do so, but and I know it was done in the Erasmus Commission case, but
I think yes,
I'd hesitate to say
it's a case.
Always should be done.
The court decides on a case-by-case basis, but we're going to be asking for a special order of costs, as the court knows. And in coming to the decision and exercising the court's discretion in respect of that issue at least, the court needs to make a finding as to whether or not what happened was bona fide or not. And if the court comes to the conclusion that it was mala fide, why should the taxpayer pay for a charade? And that's the question that we're going to come to at the end of my argument when it comes to remedy. But just on this question of whether it was bona fide or not, I do wish to spend 10 minutes just explaining to the court why we submit that it was a sham, it was a charade, it was a violation of the Constitution, the SCA's judgment, Skipper's J's judgment, and the Public Protector's remedial action. Let me just turn to 2 aspects. I only turn to 2. There are many, but 2 in particular. On page 585, Mr. Aguma explains why it is that it was a bona fide attempt at compliance. And he says on page 587 in paragraph 7, the DA has said that response to its obligation to comply has been cynically and done in bad faith. And he says, I deny this. Let me just say that when he makes this affidavit, the court knows that he does so in paragraph 3 on 586 on behalf of the first, second, and third respondents. Well, the first respondent is the company, the second are the board. Well, we question that. If he makes an affidavit on behalf of a board, one hopes that that board was correct when it gave him the instructions to make an affidavit on his behalf. And he makes the affidavit at a time when it's common cause that the board was incurably incorrect on any principle. So one questions on whose behalf...
That for the moment is a side issue on the point you're pursuing.
Yes, no, but it's relevant for costs, my lord. Because ultimately, at the end of the day, I'm going to say there are 4 individual human beings. It's the minister, Mr. Aguma, Mr. Motsoeneng, and the chairman of the board, who are potentially, and we would submit, appropriately ordered to pay the costs of this application in respect to the DA. Plus, we're going to be asking for an order that the taxpayer should not have to pay for any of their costs, including their counsel and their attorneys. And we make that point in our papers. But anyway, the point is this. He says on the next page, on page 587, that he denies it, and he says, he explains the SABC's interpretation of the report and the judgment of the SCA and this court. And he gives a background and he goes on. The difficulty for him is this. He nowhere explains why, for example, and I'll just use the example, why Mrs. Swanepoel wasn't called. And Mrs. Swanepoel comes to this court and she says, look, I made an affidavit in the application for leave to appeal against Skipper's J's judgment in the application to implement. And I explained why Mr. Motsoeneng bribed, cajoled, and he lied. And she explains all that in that affidavit. If the SABC would be close to bona fides, they'd have put Mrs. Swanepoel in the box and says, here's the evidence of Mrs. Swanepoel, Mr. Motsoeneng, your attorney or your legal representative, please cross-examine her. But she comes to this court and she says to this court, I wasn't even asked to come. And she says that, and that is before the court, not denied at all. So Mr. Guma doesn't deal with it. And what's the explanation? Explanation is it was a charade. That's the only explanation that we submit the court must draw in respect of this case. The second aspect that I want to touch upon...
Part of the problem that arose in the latter part of 2015 is that there was this 60-day time limit for the holding of the disciplinary inquiry. And that time limit expired, in mid-December?
That's right. And there was they actually didn't comply. They asked for an extension.
So, and then there was the hiccup that Mr. Makari took the view that the disciplinary proceedings had become moot.
Because of the Davis J. judgment.
Which left a very short time period in which to run an inquiry.
Correct.
Are you suggesting that in the limited time that was given to him to present the case, Mr.
Yes.
Palani?
He was doing his best to make sure that Mr. Motsoeneng was protected and be acquitted. Yes, that's our suggestion. The prosecutor was there at the behest of Mr. Motsoeneng, and I'll explain why.
Didn't he ask for a postponement to put certain material before the inquiry?
And Mr. Motsoeneng opposed. He was briefed the day before.
Yes, but that's a slightly different point. That might be to say that he was put in an impossible position where he simply didn't have enough time to present a case. It's a different matter to say that he was part of a conspiracy to run a sham inquiry.
I'll come to that. I will come to that. I'll come to that.
But ultimately it was the presiding officer there
also a sham
that decided not to grant the postponement.
Also a sham. Part of this setup, the charade, the facade. My learned colleague said that we paint Mr. Motsoeneng as the darkness. A year ago, 2 years ago, on repeated occasions, I've said, and I'll say it again, and I don't want to be melodramatic, etc. This is a toxic cancer which needs to be cut from the body. And we look at Skeppers J's implementation order where he says, he quotes the public protector who says that Mr. Motsoeneng has operated above the law in respect of successive boards. What's happened now? We've got one...
But are you suggesting Mr. Motsoeneng has influenced all of those people to act in a particular manner?
Let me ask your lordships. When your lordship reads the papers, who appointed Mr. Makari, Mr. Edling and the two initiators? Who did it? Let's look. We look at what the minister says, and there's a complaint by the DA that the minister did it, and that compromised the independence. So on 605 we see a letter from the minister to the remaining board member where she says, your letter dated October 9, this is the 605, it's in response to a letter that same day on 604. On 604, let me start off, the professor says to the minister, following the outcome of the appeal, etc., the SCA, in light of the previous view held by the board about the matter, the board is deemed prudent to request you, that's the minister, to be in charge of the appointment of the chairperson and prosecutor, and the board will concur with the appointments. That's how it starts. And we, the DA, complain about this. In order to bring finality to the matter, the board suggests that disciplinary proceedings commence without further delay, etc. Your assistance will be appreciated. On the next page, she sends a letter to say, I, the minister, hereby appoint Makari. And the DA complained. Her answer to that is curious, because what she says, which your lordship will find at the end of her affidavit, just before those pages, the short affidavit, on 601, 602, 3, she says, on page 601, paragraph 8,
she essentially says she acted in good faith.
But then one turns to, and I do ask that the court turn to this.
Mr. Katz, I appreciate that if one reads that correspondence, it creates the impression that the board itself felt that it might be criticised for lacking independence if it appointed the chairperson and prosecutor, and therefore referred to the minister, which in context would seem to be a resort of rather dubious merit. But be that as it may, she's responding to a request from the board.
Let's see what happens, my lord. Let's see what happens. I do want to push this on 64.
And Mr. Makari, if I may say, hardly acted as a co-conspirator.
Let's see what happens on 64. Please, my lord. Page 64. And I'll ask that your lordships turn to that. Because now we're turning to Alice in Wonderland.
Page 16?
64. And with respect, Justice Rogers, we don't take issue with the proposition that you put to us. But as soon as he did that, what happened? Let's see. On 64, one finds the charge sheet sent to Mr. Motsoeneng. And on page 66, the third page of the charge sheet, there's the suggestion, black and white, sent to him on the 12th of October, and this is 3 days after the 9th of October letters that I've just referred to at the end of the minister's affidavit. It says, in light of the above, the Minister of Communications has, and the words are, appointed Mr. Sandile July. And then, perhaps I should go back. I do want to emphasize this because it's not unimportant.
But can I just get clarity on this? The fact that Mr. Macquarie in the event thought that the Davis judgment rendered the disciplinary proceedings moot, are you going to be submitting to us that this too was part of some Machiavellian scheme? Or was he now not doing what you say he was being expected by his masters to do?
He went rogue.
He went what?
He went rogue.
Was he ever rogue?
Well,
I mean, it's quite a serious allegation.
It's a very serious allegation. I want to come to it, my lord. Please, please. I'm coming to it. But I need to explain. On 602, in paragraph 10, she says, this is the minister, I submit with respect that my conduct was not in contempt. I also did not... This is what she says.
Are you going to fast for us?
Sorry.
602.
Well, when I say he went rogue, I say that inference can be drawn that he went rogue for the reasons that I'm going to come to now, please.
Or simply that he was trying to discharge his functions independently and never intended to do anything else.
Let me just come to that in a second. Please, if you give me 5 minutes, I'll come to the difficulty.
Yes.
I also did, this is on 602, this is what she says. I also did not improperly interfere with the powers of the board or of the SABC. Further submissions will be made. It is open to the applicant to simply indicate it did not persist, etc. But what she explains slightly above, she says how it became about that she played no role in the termination of the appointment of Macquarie. Your Lordship sees that. But what she says effectively in 601, 602, in paragraph 8, and this is important, the last sentence on 601, but the appointments, this is Macquarie and July, were all subject to the concurrence, agreement, or approval of the board. Your Lordship sees that. And I'm going to come to that. I stated in my letter, I look forward to the board's concurrence on these appointments. There was no expectation that the board would simply rubber stamp my recommendations. But now, let's see what actually happens. On page 67, which is the page after the charge sheet. So we have this dispute. Who actually appointed these people? Let's see what happened. So what the minister says is, I made this recommendation. Who would appoint? Well, ultimately the board would do it, and they wouldn't be expected to be a rubber stamp. That's what she says. And that's what the minister tells this court. She tells this court last week. What actually happened is on page 67. On the 14th of October, there's a reference number, SABC round robin B31 14 10 15. And then it's got a board, and it says, dear members, and this is from the group company secretary. May I just turn to the middle of the page? In order to ensure the independence of the board, a request was submitted to the Honourable Minister to appoint an independent chairperson, etc., in respect of the disciplinary proceedings. The Honourable Minister has subsequently approved the appointment of Macquarie, etc. The Governance Committee has approved the appointments. And then there's a resolution, and this is what he's put up. This board approved. It didn't rubber stamp the minister's appointment. But who is in the board? Turn up the page, the top of the page, attention, there are 9 names, including Mr. Motsoeneng. Motsoeneng was involved in appointing Mr. Macquarie and Mr. July.
Well, that's not the evidence, and knowing how minutes come into existence, if one is just carrying forward a template of who the directors are, I think that's rather slender evidence to say that they would have been as silly to include Mr. Macquarie as, Mr. Motsoeneng as a director. Is there any evidence that Mr. Motsoeneng received this and signed this as a director?
If he didn't, then they weren't called to do it. There are 9 names there. There were only 9.
Yes, but it seems to be common cause that by the 14th of September, a month previously, they were...
that was... 2015. Sorry, my lord, this is 2015. There are 9 members. The Act says there have to be 9. They're the 9 names, including Mr. Motsoeneng. Mr. Motsoeneng approved, in the words of the minister, didn't rubber stamp. He approved his own chairman of his disciplinary committee. He was the one who approved...
But he was part of 9 people.
Excuse me?
He's part of 9 people.
Absolutely. Absolutely.
Well, the evidence put up, the answer is that the inclusion of his name there was an error.
Well, then they weren't for it.
That may be.
That may be so.
But you're arguing a conspiracy point. The fact that they weren't for it because Mr. Motsoeneng was precluded from participating in this decision is a different matter.
Well,
Are you not taking a bridge too far here on this particular point?
those are submissions, and certainly not a bridge too far. Your Lordship just has to read Skipper's J, just has to read the SEA, just read Javer's J, read Skipper's J in the implementation order. No bridge too far. You heard your Lordship put to a learned friend, the second applicant this morning for an Amicus, well, why are you here? And then they say, well, because of the local content. And then the point being, well, we all know what this is about. I read in the News 24, and I don't want to need evidence, and I invite our learned colleagues to deny it. I read in the on Sunday that Mr. Motsoeneng now, today, 16th, whatever it is, or November, is still sitting in the same office that he had as COO. The same physical office, and I invite Mr. Bester and Mr. Du Toit to deny that. Is he sitting in the same physical office? And they say it's well guarded on the 27th floor of SABC.
What's that got to do with the issues?
He is the controlling animus. There's one non-executive director. The public protector said he's the one who operated above the law in respect of successive boards. What's the problem? What's this systemic problem, this chronic difficulty at the SABC? This toxic difficulty that's called Mr. Motsoeneng. That's the difficulty. And your Lordship can say, well, Mr. Motsoeneng's here is an error.
Yes, I just think if you're wanting to advance the argument you've just summarized, there might be better arguments than this one.
Well, I can't think of a better argument to say that a disciplinary proceeding is a charade.
No.
When the person who is subject to it
matter.
helps point the chairperson and the initiator. I'm charged with an offence at the bar. I go along and I help decide who's going to prosecute me. I go along and I help who decides the chairperson.
But your case is that the board did just rubber stamp the minister's decision, which is why there was interference. Now, you can't run that case simultaneously with saying, well, the board did really make the appointment, and the real problem is that Motsoeneng was party to it.
It's all part and parcel of the same difficulty. It's a basket. And to cut this into slices of saying the narrow aspect of, well, the board didn't rubber stamp, or they did rubber stamp, whichever way you cut it, there's a charade at stake here. Mala fide, it's a bad process, and there's not a word from anybody as to why Mrs. Swanepoel wasn't called. And the excuse, well, the Mukari problem happened and there was a time problem. It's not dealt with on the papers. There's no suggestion. Well, we tried to phone Mari Swanepoel, but her phone didn't ring and we were in a rush because Mr. Eerdling said that proceedings must go forward. There's nothing like that. So it's just conjecture, and it's been the simplest thing in the world for somebody from the SABC. They know because it's in our founding papers to say, yes, it's true we didn't call Mari Swanepoel, but she was in hospital. But there's nothing. And she would have proven the case. Well, she may have. We don't know. Charade. Put her in the box and let her evidence be tested. Didn't happen. So, my Lord, we would submit that on the common cause facts as set out, the only conclusion that the court can come to is that it was a charade, mala fide, an attempt to comply, and the attempt failed miserably for all the reasons that
Just remind me the evidence of the appointment of the persons who did actually act as prosecutor and chairperson in the event, Mr. Eerdling and Mr. Palani. There, the minister says she wasn't involved. Now, I know you raise a point because there's some board member who says, well, the board also wasn't involved. But what is the state of the evidence? I'm not sure on the material before us we can find that the minister had any role to play in the appointment of the BT.
Good question, Mark. It's a good question. That's part of the problem. It's part of the problem. What is their status? Who appointed them? That's the question. Let's assume it wasn't the minister. Who was it? Was it the professor? Was it Mr. Motsoeneng? SABC don't tell you.
Well, there's very little here to come to that any definite conclusion as to who appointed
No,
him.
the problem, my Lord, is this. There is nothing, not very little, there is nothing. It's not little. It's the simplest thing in the world to say, there's a public protector's report, we have to comply. Skipper's J found this, the SCA found this, the Constitutional Court in Kandla found this is what we did. Terribly sorry, we were bona fide. They don't tell you what they did. When we say it was mala fide and charade, But they say, no, we bona fide, but they don't tell you what they did. What inference can you draw from their failure to tell you who did what and when they did it and why they did it?
Mr. Katz, I just want to be sure, though, who the allegation of mala fides is directed at. The chairperson of the inquiry, who's on the face of it an independent advocate from Bloemfontein, do you say that he was a knowing party to a charade, or that he was simply chairing an inquiry that was presented in an ineffectual manner?
Well, there's a case called Tantush, in respect of which there's reference, that's a judgment of His Lordship Mercy J, in respect of which there's an application of cash paymaster from the late 90s.
Now, can I just ask what the answer to my question is?
Where there is a review of, in those cases, one was a tender case and one was a refugee appeal board. What the courts say is, when it comes to Rule 53, the presiding officer's job, the decision maker whose decision is impugned, general rule is you put up the Rule 53 record and you file an affidavit to explain what happened. But you don't file an opposing affidavit unless, and this is the important point, to answer your Lordship Rogers, there's an allegation of mala fide or bias in respect of the decision maker. On the founding papers, there is a suggestion of charade, and it's not answered by Mr. Polani and Mr.
That's what I was concerned with, because it wasn't clear to me from the founding papers that an allegation of mala fides was directed at the chairperson of the inquiry. So can you just show me where I will find that?
My Lord, I just want to finish the point. To the extent that your Lordships find that it's not necessary to go to certain aspects of the mala fide, bona fide aspect, we don't ask that the court make a mala fide finding against Mr. Edel and Mr. Polani.
No, but I want to know what your case is, and it's not clear to me that that is even your case. It's not a question of whether we go there or not.
My Lord, our submission is the entire process of the disciplinary inquiry was a charade. That's our case. In order for that submission to come home, obviously by necessity, those involved in the disciplinary proceeding itself must have somehow been implicated in that charade, that sham, by necessity. But I don't want to be suggested that, and of course the simple issue is, Mr. Edel and Mr. Polani could have said, this is what we did. There's nothing. How did your Lordship deal with this? You can only come to the conclusion we would submit that it's a charade. We make the point that Mr.
But coming back to
Aguma
the question raised by my learned brother, he specifically asked, can you point out in terms of the papers where you, in the founding affidavit, made that serious allegation against the chairperson of the disciplinary committee?
Well, let me turn to page 31. On page 31, we start in paragraph 63, and we say, if the court will find we're entitled to determine the merits, and your Lordship knows this argument, the one argument I'm going to leave to my friend, this question of whether or not it was open for the SABC only to go to the question of sanction, or whether they need to go to the merits as well. We deal with that before paragraph 63, but in paragraph 63 and following, we deal with this in turn. In paragraph 64, we say the board, SABC's chairperson and the minister deliberately engaged in a pattern of conduct that rendered the disciplinary proceeding wholly ineffective and futile, and which did not comply with, and I don't need to repeat the SCA judgment in Madam Skipper's jail, etc., etc. And then we explain in detail in paragraph 66, in summary, the record available indicates that, blah, 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 and we go on and on and on. Yes. My Lord, the point is this, none of this is answered. We don't have an answer to this. And on Plascon Evans...
If a chairperson of a disciplinary inquiry who's faced with an ineffectual presentation of the employer's case may feel he's got no choice but to refuse postponement because it hasn't been properly justified, and to dismiss the charges because there's insufficient evidence. Now, one can quite properly conclude that that was an ineffectual process without implicating the chairperson.
I've made that point, my Lord. I've made that point. If that's the court's finding in respect of the chairperson of the disciplinary, or Mr. Polani, we're not going to quibble with that.
But what certainly isn't explained is why Mr. Polani is as it were, given the brief on the morning and told that he's got to be ready to run the case that evening.
Who gave him the brief, my lord?
Well, we don't know.
No,
Not on the papers here before
No,
us.
that's my point, my lord. When there's a suggestion of a charade, who gave it to him? I asked rhetorically. This is Alice in Wonderland stuff, and that's why it's all very well saying, Mr. Motsoeneng's name happens to be one of those people who appointed his own prosecutor and his own chairperson. It's all very well sort of swatting it away. His name shouldn't have been there. But everything points, everything, human experience, context, points to him being the driving force behind his own acquittal. He was the COO at the time, and you recall that at that time, he was in law suspended from being the CEO for various reasons. But he chose not to be suspended, special leave.
Can I ask a different question which arises in the disciplinary inquiry, and I'm sure you are going to come to it at some stage. The first basis on which you attack the disciplinary inquiry is that the Public Protector's report did not permit an inquiry which concerned itself with the merits but only with sanction. At the moment, the board now seems to accept that state of affairs. I'm not sure that Mr. Motsoeneng does. But either way, it may well feature and be decided in the review in Gauteng. It seems undesirable, unless we're forced to do so, to decide the disciplinary review on that ground.
We would agree with your lordship, subject to what the Public Protector says. It's not something that I intended to argue, and I'll leave that to Mr. Labuschagne, I said a few minutes ago. The one thing that the DA submit, this court needs to find, and however you deal with that particular aspect, we made our submissions that the Public Protector is correct in how they interpret the remedial action and its consequences. We support the Public Protector. That's really a Public Protector issue rather than a DA issue. The DA's issue is this was a charade mala fide in order to subvert the Constitution and the judgments of the courts and the Public Protector, however one calls it.
So
that's
one
our
might,
submission.
assuming you are right on the charade argument, one would say that this proceeding must be set aside either because it was impermissible having regard to the Public Protector's report in remedial action, alternatively if her remedial action does not have the meaning for which the DA contends, it didn't achieve its purpose of inquiring properly into the merits.
So maybe
your argument about a charade is that the merits were not properly inquired into.
as a piece of the court.
That question will only arise if
Indeed.
the merits are up for debate in the disciplinary inquiry, and that
No.
is something that might stand or fall by the Gauteng review.
It's subject to this, because even if the merits weren't up for grabs, so-called, along the lines of the Public Protector's interpretation of her own report, it was still nevertheless necessary for the SABC to lined up Mrs. Swanepoel for purposes of sanction. They didn't bother to phone her. So whichever way you look at it.
Well, I'm not sure about that. If you accepted everything the Public Protector said, I'm not sure what Ms. Swanepoel could still add to it.
Sanction. She could have...
In regard to sanction?
No, of course, she could have said, my lord, the evidence is devastating as far as we are concerned. Mr. Motsoeneng tells in an affidavit, Skipper's J, that the reason, and he says this in terms, the reason that Mrs. Swanepoel hasn't made an affidavit is because I couldn't get hold of her. That's what he says.
Yes, but
Then,
this may be another question, but he's not facing a disciplinary charge. He perhaps should have. That in the Western Cape review proceedings, in the Skipper's case, if I can call it that, he didn't tell the truth about Ms. Swanepoel. But once he's not faced with that charge, how does calling her to say, well, he also lied before Skipper's J?
sanction, my lord, sanction.
Well, that's really saying here's another thing he did wrong, so dismiss it.
Not just wrong, he's a liar and a perjurer. He perjured himself in respect of the proceedings before this court, and effectively the SCA. How can that not have... So, for example, there may be some... Well, let's say his matric certificate. Let's say he's guilty of having, let's say, used Mr. Kloppers to avoid the matric difficulty. Let's assume that. It may, 20 years down the line, well, he's become a mature man, as Mr. Orens has said about him. You shouldn't fire him, blah, blah, blah. That was Mr. Orens' argument. 20 years down the line, he's still lying about the very issue. Of course it applies to sanction. It's not just about him. In 20 years ago, he was a young man, and maybe he's caught up in the euphoria of 1994. They needed a vendor-speaking person in Bloemfontein to start off the radio station, or whatever the language is. So he lied about his matric certificate. Let's forgive him. But no, not when 20 years later, he lies and he lies and he tries to bribe the person who he's lied about with SABC money. And your lordship puts to me that wouldn't have anything to do with sanction. We would disagree. It's got everything to do with sanction. And not just sanction in respect to the disciplinary proceedings, sanction in respect to the remedial action. The remedial action asks that the money that was fruitlessly and wastefully expended be recovered from those who did it. There's not an iota of evidence from the SABC they're even considering that for all those labour disputes that have millions of rand, 28 million in one calendar year wasted by Mr. Motsoeneng. Whose money is that? It's our money that she filed. And there's no evidence that they even consider charging the man with that and trying to get the money back from him or any of the others. We would submit charade. Whichever way one looks at it in the context of this case and human experience, the only conclusion that we submit that this court can come to. He was the driving hand, start to finish, of that disciplinary proceeding. So my lord, with that in mind, may I turn to the other case. In the other case, it raises a range of interesting issues, only one of which we submit is of any proper interest. The other bits of interest, as I might call it, are retreads and defective retreads of arguments raised in this court and other courts over and over and over and been rejected by this court and the SCA over and over and over, such as the stay application, such as the non-urgency. These issues, the parliamentary PCC prematurity argument, they all have been dealt with by this court, and your lordships will be happy to follow in the footsteps of those before your lordship to reject those arguments with the contempt they deserve. There's one argument that I do need to emphasize, and that is that on the 14th of September this year, when the SCA endorsed Davis J's order setting aside the appointment, what became the status from a labour rights perspective, from section 23 of the Constitution, situation vis-a-vis Mr. Motsoeneng. And that's the only issue of true interest in this case. Our primary submission, perhaps not articulated in our heads of argument the way we would have preferred, is this. Mr. Motsoeneng was an ordinary executive employee of the SABC until such time as his statutory appointment as the COO. At that point, there was a break in his labour rights, and he developed new labour rights such as they may have existed. So, for example, by analogy, he was the executive manager or supervisor at Telkom. He gets offered a job at the SABC as the COO, and he accepts it, and he becomes the COO of SABC. What happens to his Telkom job? It disappears. So his labour rights vis-a-vis the SABC, such as they were when he was appointed the COO, disappeared, by analogy to the Telkom example.
So are you saying that whatever position he might have held previously, that have disappeared in terms of his rights?
For two reasons. One, it was a statutory appointment by an appointing body different to his original appointing body. He had a totally new regime imposed upon him. This wasn't a promotion from, for example, a packer to a driver, or from a clerk to a supervisor. It was a whole new regime that applied to him with a whole series of different rights and obligations. He became a member of the board as appointed in terms of the Broadcasting Act. The Lordship knows the provisions of the Broadcasting Act dealing with governance. It's a very different type of position, and your Lordships will know this. He's not, when he gets appointed as the COO, he is not, for purposes of this debate, part of Part 7 of the Broadcasting Act, which deals with the staff of the corporation. He is subject to Part 5 of Chapter 4. And there one has a different staffing regime, if I may call it that, compared to, as I've explained, Part 7. And who appoints him? That one finds Section 13. So, by the way, Section 26 is the staff. But if I may just turn to Section 13. The 12 non-executive members must be appointed by the President on the advice of the National Assembly.
In my understanding, there's 15 members, isn't it, in terms of the board?
12 non-executive appointed by the President on the advice of the National Assembly. Subsection 2, the non-executive must be appointed in a manner ensuring, etc. Not relevant for our purposes. Then it says the President must designate one of the members of the board referred to in subsection 2 as the chairperson and another member as the deputy, both of whom must be non-executive, etc. Perhaps just for sake of completeness, I'm going to jump and then come back. Section 13.10 deals with quorum, and at some point on the papers there was a suggestion, I think by the Minister, that what we submit the quorum provision means is not correct because of Section 66 of the Companies Act. To put paid to that, Your Lordship, Mr. Justice Rogers' judgment in De Vries v. Eden District Municipality, in particular paragraph 29, puts paid to any suggestion that Section 13.10 doesn't mean what it says it means. We've included that in our heads of argument. I know the Minister has now turned around and agreed with the what we submit is the proper interpretation of Section 13.10.
So the argument essentially is that the Minister could not have relied on Section 66(1) of the Companies Act to say that the board is correct because it doesn't apply.
That's what she said. That's what she's alleged to have said. Now she says, well, she doesn't say that, but what she now says is that it's true that there are 9 and therefore Mr. Guana's appointment was improper because of the fact that there weren't 9. She says that. Now, I mean, beforehand, Your Lordship knows that debate. The point I was making is that the big point I was making is that once Mr. Motsoeneng was appointed for purposes of this debate to a position under Section 12B, which one of those 3 persons, Chief Group CEO, CCO, and Chief Financial Officer, they're the executive members. Once he was appointed as such, whatever rights he may have had, which he certainly may have had rights, they fell away. They disappeared, as in my words, which it
becomes a dangerous thing to be appointed in an act that can potentially be reviewed, because you say if through no fault of yours, the appointment turns out to be invalid, you're left with nothing, not even what you had before.
That's the way the world works. That's the way the world works. Telkom, let me, and Your Lordship will recall in the Similani judgment, what happened to Mr. Menzi Similani. He was the Director General of the Department of Justice. He came across, became Deputy NDPP. A couple of weeks later, the President decided, well, new NDPP, and they appoint him. Now, what would have happened, as it turned out, could DCJ set aside that appointment? What would happen? Let's assume he hadn't become the Deputy in that little window period. Would he have gone back to become the Director General of Justice? Obviously not. It would be absurd. The Telkom example. So these, and I make the point, Your Lordship.
Well, the position is he might remain an employee, as it were, without portfolio, and some decision would have to be made in the employment context as what then to do with him.
At the Department of Justice?
No, I'm back to Mr. Motsoeneng. If his appointment as COO is set aside, one might say, well, that doesn't affect his employment relationship, and he's there with whatever his remuneration package is until his employment is either lawfully terminated or he's redeployed lawfully to some position.
That's alternative argument. That's alternative argument. Your Lordship knows that's alternative argument, that were that to be the position, this alternative argument, that he maintains some labour rights, then what the SABC did in this case was a blind, jackbooted approach that he is who he is, and therefore we're going to keep him where he is. And when your Lordship has regard to that attitude of the SABC, which ignores your Lordship's suggested approach, what conclusion can you come to other than he is the SABC? With respect. The SABC don't even consider, well, the CIO position was set aside, what to do with him. They don't think like that. Why that? Because it's him thinking. And that's our submission.
Are you suggesting the professor is not thinking at all? The professor of the board, is he not thinking at all on your argument? He's also part of the board.
Well, at the moment, he is the board. If we weren't in Alice in Wonderland, where's there anything what he was thinking? He would have told your Lordships, Professor. Not a piece of paper from him. Doesn't need to. Mr. Motsoeneng is his spokesperson. We watch press conferences. You can take judicial notice of what happens. The professor talks a little bit. Things get a bit rough. Waters get a bit rough. Who dives into with the paddles? Mr. Motsoeneng. I didn't just say it. It's there. So, my Lord, what we submit is. That's what I mean. Lord, let's look at the relief we seek from it. I see we've gone past the T-agent, and I'd like to carry through.
Yes, you may.
The relief we seek in this application, in the main application, is on page 1. And I want to emphasize what it is that we seek, because what seems to us to have happened is both the SABC and Mr. Motsoeneng, in their approach to this case, have mischaracterized what we seek. And once it has become clear what we do seek and not what we don't seek, a lot of their argument falls away. So in paragraph 1, which is on page 2, there is a declaratory prayer, which is that it is declared that unless and until all the negative findings are reviewed and set aside. Do your Lordship have that?
Yes.
Now, what they say we seek ignores the words unless and until reviewed and set aside by a court. It's almost as if those words don't exist. And what we say is that it's not dissimilar in kind, in effect, to that which we sought and were granted by Skipper's J, affirmed by the FCA, which is a suspension pending something else. So it's a declarative that until something else happens, Mr. Motsoeneng may not be there. In those cases, it was that he couldn't be the COO. Now, it's not that he can't be the COO in this interim space. He can't be there at all, bearing in mind the charade and bearing in mind the 2.5-year dance that the taxpayers paid in order to keep Mr. Motsoeneng as the SABC. So that's why we submit that how they characterize what we seek is wrong. It's not a final interdict or anything of it. It's a declarator that for an interim period, he may not be there at all. He may not hold any position at all in the South African Broadcasting Corporation. Now, may I just flip through Mr. Motsoeneng's head
Just before you go further, but that does not imply he might not be present to be an employee of the SABC.
It does.
According to you, it just can't hold in the position.
Sorry, Molo?
Does that also characterize he can't be an employee?
Can't be. Indeed. It's far-reaching, but far-reaching cases call for far-reaching remedy.
Sorry, do you mean he can't be paid?
I'll come to that. I'll come to that when I come to, in particular, the 2 judgments of Skipper's J, affirmed by the SCA. I'll come to that question. Well, I can just imagine that if your Lordships make an order to the effect that he can continue being paid while on so-called suspension. One wonders how many millions of rand his salary will increase in the years between your Lordship's order and when he is finally...
We don't necessarily need to decide that he must or mustn't be paid, but the question is whether we should make an order which definitely declares that he mustn't. In other words, certain legal consequences might flow from an order, but I'm not sure that we should be determining that in labour law the effect of what has happened is that he shouldn't be paid at all.
Correct. But your Lordship put the question to me, and I would answer it in the way that we know what's going to happen. We've seen this song before. The record doesn't change.
Well, in regard to timing, can I just ask, I think the Gauteng review, have the supplementary founding papers been served yet by the SABC?
We have no idea.
Is your client a party?
No,
a cited party?
we were not cited as a
Are
party.
you intending to intervene?
I don't have instructions in that respect yet. I've given certain advice, but we don't have instructions.
The public protector
is certainly a party.
Yes, but has she filed a notice of opposition, or is she abiding?
Well, I don't know, but what I do know is in this court, before Hlaudi, the public protector made submissions, and you'll hear them later this morning, which suggested that case is a no-hoper. And
I'm not so concerned with whether it's a no-hoper or not, but what is the likely time frame for it being decided, because it really should be decided sooner rather than later.
Absolutely. We're not involved. It should have been on the roll already in a case like this. But of course, who's driving the case? The SABC. And now what I've heard now in the last couple of weeks is Mr. Motsoeneng's applied to intervene.
Well, I would have thought that given this case and the role your client has played up to now, it certainly has an interest sufficient to intervene in that case. But of course, whether you wish to or not.
Not dissimilar to the advice that I've given, but we'll take that as it comes.
No, because
my attorney's sitting in front of me and she smiles.
Because it's not only the it's not the applicants who dictate the pace of an application. The respondents, if they oppose it, have certain rights to ensure that time limits are complied with.
Yes, my Lord, your Lordship is absolutely right. And your Lordship is right. And my Lord, in Samuel J's judgment, he refers to a case, and just for the sake of completeness, I just want to hand up an extract from the case that he should have cited, but he cited the wrong case entirely because of me. What the case was about was the doctrine of preemption. When the SCA approved Skipper's J's order that Mr. Motsoeneng must be subject to a disciplinary inquiry, one of our arguments before Samuel J in the stay application was that but the SABC had preempted their right to bring the review that is now pending in the Gauteng court because they'd complied with they'd purported to comply with the public protector's remedial action. Your Lordship knows the argument, your Lordships have seen it. And what Samuel J did was he dismissed the stay application inter alia on the basis that the preemption argument may be a good one in the Pretoria court. Your Lordship will recall that.
But are you wanting us to find that the Gauteng review has been preempted?
Well, I'm just making... The doctrine of preemption was, in our submission, given a proper stamp of approval or set out the criteria in a case before the Supreme Court of Appeal, in a case called Von Arber, which I've just given your Lordships. In Samuel's judgment, he referred to the Von Arber case, but in not this case, another case which was decided by the Constitutional Court. And I wouldn't want your Lordships to fall into the same trap that Samuel J...
Now, why do you think we will fall in the same trap?
Because you're not being offered, and you wouldn't, because I've now given you this, which I should have given to Samuel J, but now I'm giving it to your Lordship, so your Lordship can avoid the trap that we set for Samuel J and fell into.
Mr. Katz, the issue is not so much the doctrine of preemption. Obviously, it can apply, I think, to review proceedings as much to other sorts of proceedings. The question is whether there was a waiver with full knowledge of rights, and the SABC's case is going to be, and I presume Mr. Motsoeneng's in the Gauteng review, that they went through the disciplinary process on a particular view of the public protector's report in order that the merits were up for grabs. And in doing that, they now think that they've erred, and what they have to do is attack the public protector's report. It doesn't seem to me a slam dunk case of preemption.
I've never made that submission, but it's something that it's a factor that your lordships will take. It's a factor that Sir Mela J took into account in his decision to reject the stay application, and we would offer the same proposition to your lordships for the purpose of deciding the stay application that is now before this court. So, when your lordships suggest it's not a slam dunk, it's certainly an argument worth pursuing. And that being so, we would submit that it's a factor, and we would submit an important factor. But anyway, your lordship knows the argument. The stay application has been tried, it's tested, and it's rejected. Your lordships are confronted with it again. The urgency, I'll come to that. I will come to that. But what I was dealing with was the prayer 1 of the main case. Before I continue with that prayer, I do wish to just flip through very quickly the heads of argument of Mr. Motsoeneng with reference to some aspects of our bundle. In doing so, I want to address one aspect which comes through in respect of all three opposing heads of argument, and that is that were your lordships be inclined to make any declarator under 172.1a, the court should consider making a suspension or limiting of retrospective order in respect of those declarators because of 172.1b, the just and equitable relief. I have three submissions to make in that respect. Nowhere on the papers do we find it suggested that that would be just and equitable by way of, and importantly, and I want to emphasize this, evidence. Not argument, evidence. And for that proposition, we referred to the case of Darwood. I hope it's in the small bundle that I gave you. Oh, may I just hand up the case? On paragraph 17 of Darwood, I'm handing it up. It says,
I was trying to understand the retrospectivity point. Why is that relevant to paragraph 1?
No,
I thought it was raised in regard to Mr. Tugwana.
3.1 and 3.2 of the other case, yes. Yes. But I'm making the point as a general proposition that your lordship is now confronted with prayer 1, which is a declarator, and in regard to all the other prayers, 2.1, 2.2, etc., they all are of a similar type, which is a declaratory order. And I just want to put to bed the notion that were your lordship to come to the DA's assistance in respect of the declarators, what you do then do. For example, your lordship put to me about for example, his salary, if it is to be declared
a declaratory order can't be retrospective or prospective. It declares the position.
Well, my lord, with respect, that's a debate that I've been having with myself for 15 years.
Now you're having it with me.
And it seems that the minister says that to the extent, well, it could, my lord, let me just say this.
It's the consequential relief, such as setting something aside, which can be retrospective or not.
Let's assume you declare, for example, that Mr. Gwana was unlawfully appointed as the COO, acting COO. Let's assume you make that declaration. As we understand the argument, you may then suspend that declaration in validity until such time as there's a proper COO appointed. That's how I understand the argument. I understand that there's a distinction between suspending or limiting retrospective orders in respect of legislation rather than conduct. I understand the conceptual difficulty. I understand that. But it seems to me that the Constitutional Court has, in the last few years, there are various cases, Masetle in particular, developed the notion that that the court can, under 172.1b, suspend the declaration of invalidity of conduct. But the point being, we submit, your lordships don't have to go there for a simple reason. There's no evidence of any kind that any just and equitable remedy should flow from your lordship's declarations were you to come to the conclusion that a declaration was appropriate. And that's paragraph 17 of Darwood. So this whole intellectual debate of whether you can or can't suspend, limit retrospectivity in respect of conduct, declarations in respect of conduct, is interesting, but it doesn't apply in this case, despite our learned friends trying to squeeze it in. So in paragraph 17 on page 953, what the Constitutional Court says is our constitutionally recognized the separation of powers. Within this scheme, the court is given special and onerous responsibilities once it concludes, etc. Now, the important sentence is the next one. Such an order may be tempered, and this is the order that our learned friends suggest. Such an order should be tempered by ancillary orders that are just and equitable. That's the wording of the Constitution. In light of this constitutional claim, this court can, this is the important word, can best carry out its task if careful and detailed what? Evidence. And we emphasize the word evidence, and in this case there is none. So when your Lordship comes to decide, well, what about the Minister, the SABC and Mr. Motsoeneng, your Lordship will wrap them over the knuckles for providing no evidence at all. Yes, they provide argument, the next sentence. But no evidence are placed before it by those in government qualified to do so, particularly when legislation is under challenge. So there's a suggestion from the Minister, well, we need a COO. The scheme needs a COO. So let Mrs. Stugwana stay, despite the fact that she's unlawfully appointed. That's the argument. There's no evidence of that. Nothing. And if they had put up evidence, the DA might have dealt with it. Probably would have. So we suggest...
So your argument, in the absence of any evidence, the court can't go so far?
I wouldn't say the court can't go so far in all circumstances, but in this case, because there's no evidence, the court should be very slow to come to the assistance of a party who says, listen, yes, it's true that we acted unlawfully, but temper it with an ancillary order that allows, for example, this unlawful position to continue, which is what they say. Now, why should your Lordships come to their assistance when they don't assist your Lordships to come to that just and equitable result?
Well, they may say it's the statutory scheme that there must be a COO, or at least an acting COO.
Well, when your Lordship puts that proposition to me...
Of course, it does seem rather Alice in Wonderland to say we must suspend the we must allow an invalid COO to fulfill the requirement of the law that there must be a COO. I appreciate the incongruity of the submission.
And let me just say, just two aspects of this. There's no evidence, or argument for that matter, why Mr. Oguma can't fill his acting COO position. Two, it allows for an abuse. So you have a non-court board, minister or whatever, appoint somebody unlawfully, knowing at the back of their heads, well, we've got this COO who's unlawfully appointed, but we know, don't worry about it. The courts will let this person continue for a while. And then you won't be able
either way, this seems to relate primarily to the position of Mr. Kwana. Nobody seems to say that, well, I'm not sure if anybody says that if we find that Mr. Motsoeneng's appointment to corporate affairs must be set aside, that it's imperative that he should nevertheless be able to, either that he's done anything since his appointment that needs to be saved, or that he's going to have to do things afterwards which need to be preserved.
I look at the council in this room, Mr. Labaskachny, Mr. Mayosi, and Mr. Bishop in my turn, and Mr. Benetti, who've been here since day one. The rest haven't. Who knows what will come out there? So I would predict that that's not going to be argued. I just don't know. But there's no evidence that any declaration that the court might be inclined to make should have an ancillary order tempering the effect of it. That's, as I lead into our learned friends' heads of argument, as a general proposition, I make that. The suggestion that this just and equitable suspension, limiting and retrospective has no place in this case for the reason that I've articulated. It may have in some other case, and it may even have in cases, for example, where there is no evidence laid, for a variety of reasons. But in this case, it's certainly not appropriate. I want to just turn to Mr. Motsoeneng's heads and deal with, and I'll come back to the broader spectrum of the relief, but prayer 1 is an important one. And of course, if your Lordship is with us in prayer 1, then the prayers 6 to 10 of the Disciplinary Committee hearing may not be appropriate. But I'll come to that. Let me just jump, but I'll come back to that. On page 13,
am I right that in the case of Mr. Motsoeneng, we have heads of argument, yes, in the latest review proceedings, what you've called the main case?
Yes.
The only heads we have from him in respect of the disciplinary case were the ones filed in May.
That's how I understand it.
So you're now talking about the recent heads.
Then in paragraph 38, I just want to touch on 38 and 39, and I'll come back to the earlier point. But I just want to knock this out the way because we would submit that what I'm going to say about paragraphs 38 and 39, with all due respect to our learned friends, should be marker as to how the court should regard Mr. Motsoeneng's submissions. In paragraph 38, it is suggested that Davis J has already categorized alleged public interest the DA has in the SABC as a clear instance of politicking in the court. And that's the theme of Mr. Motsoeneng. What is the DA doing politicking in this court? And then there is a quote from paragraph 4 of Davis's judgment. I've handed your lordships a bundle where I'd like to just read the balance of that paragraph to demonstrate the difficulty with that submission. It's on page 472 in paragraph 4. It says what the last words in the quoted paragraph are become commonplace in South Africa. And this is what Davis J goes on to say. And I ask that your lordship emphasize this. Or we ask that we emphasize your lordship. The applicant, that DA, thus bases its case on arguments which contend that the decisions both to recommend and later appoint Mr. Motsoeneng as the CIO are procedurally and substantially irrational. These arguments require this court to examine and evaluate the merits of these submissions, notwithstanding, and this is the point, notwithstanding that this dispute can be described as lawfare. It is the court's role to examine whether the appointment was made in terms of the principle of legality, only after which deference must be paid to the choice of a democratically elected minister. And this is the next two sentences we would urge upon your lordships. Courts are the custodians of the principle of legality as it is sourced in the Constitution. Where this principle is invoked, and we invoke this principle, courts are obliged to enter the arena. And then there's a sentence, beyond the scope of this principle, invitation to be a custodian must be firmly refused. So to suggest, as Mr. Motsoeneng does, that the DA is politicking in this court, inappropriately it's suggested, and with all these other references, has been rejected by this court, been rejected by the SCA, been rejected by the Constitutional Court, and Mr. Motsoeneng still comes to this court and he says that. And your lordship puts to me, is this a charade? In the next paragraph, they suggest, Lord Law warns in prime media broadcasting. Now your lordship should recall that judgment. It was a split bench of this division between, on the one hand, Savage J and then Lord Law J, with whom Henny J concurred. Perhaps Mr. Motsoeneng didn't realize that on the 29th of September, that Lewis J, for a full Supreme Court of Appeal, rejected the thinking of Lord Law J and went with the Savage J line of authority. So we would suggest that when your lordship has regard to these types of difficulties, of quoting a split decision of this court, which has been rejected by the SCA a few weeks ago, your lordships will be minded to...
But the assertion is essentially made is that the DA wants to come to court whenever they can't win their battles outside.
Yes, that's the argument. These are not battles outside. This is a battle for legality. And it's not about votes, getting votes in the next election or votes here and there. This is about whether or not, and that's your lordship's task, and what Davis J says. When it comes to either the DA has standing or it doesn't, and it does have standing. The courts have recognized that from as long ago as Samalani. And the question is this: where this principle is invoked, the principle of legality, your lordships are obliged to enter the arena. And to suggest otherwise is contrary to everything the Constitution holds dear. In other words, whether it's politicking, whether it's an NGO, whether it's an individual, Mr. Glenister, whether it's the Treatment Action Campaign, if they come to court and they say, look, there's a problem with legality, it's not open to a court to say, you are a political party, go and fight your battles at the electoral, in the streets, if it's legality. And that's
but it appears that these type of cases are on the rise and we're being swamped with it.
Yes, and you know why, my lord? Because Parliament is failing. That's why you need it. Parliament is failing. That's what Nkanda judgment said. The Constitutional Court said to Parliament, why aren't you, Parliament, holding the executive to account? And erupted Parliament.
I think on this particular argument, that would probably be Mr. Motsoeneng's submission, that in this particular instance, Parliament isn't failing because they've got an inquiry underway.
Well,
I mean, he doesn't say you can't be here. He says we should exercise our discretion not to...
Well, firstly, it's a bad...
I know there are other answers to it, but...
No. In Mazibuko versus Sisulu, the same type of argument where Parliament changing the rules and therefore you, Constitutional Court, don't get involved in it. Your Lordship will recall that. Point is this, 2 points. Firstly, it's an irrelevant suggestion. And in any event, it's wrong.
Why is it irrelevant if Parliament has decided, listen here, we're now going to have an inquiry and we will deal with it appropriately?
For 2 reasons. your Lordship is confronted with legality challenge. It doesn't matter what Parliament find, one way or the other. They could find he's a bad guy, a good guy, he's bad for the SABC, it's irrelevant. Your Lordship is challenged with legality. That's first. Two, and in any event in this case, the PCC, the suggestion, premature, that's the argument about prematurity. What's the PCC going to do with Mr. Motsoeneng? They have no role. We've seen their terms of reference. We've seen Section 13. We've seen how the scheme of the Broadcasting Act works. He's an employee on his version. He's no longer a member of the board. I mean, it's absurd that the PCC can be suggested to deal with a non-member of the board. That's all they can deal with.
So you're saying he's no longer even a member of the board, so therefore whatever the PCC might decide doesn't affect Mr. Motsoeneng?
Common cause. That's common cause. It's common cause.
Because
well, when I say he's no longer a member of the board, I just want to remember, my Lord, he's not only the shadow. I say in truth he is the board, but officially, as far as the legality position, he's not a member of the board. On his own version, he's not a member of the board, but he sits in the same office that he had before, according to the News 24 website that I read. 600 million rand this, 600 million rand that. And South Africa beat Australia twice in cricket. I read there, why? We can't hear it on the radio. It's one of the things I like going to. Mr. Motsoeneng. He didn't send Nicholas Germanis or whoever it was to go and comment on the cricket. But anyway.
But why should the SABC favour your liking?
Not mine, but maybe I should listen to different type of music, but that's not the point. I mean, it becomes funny in a way. When I was before Skipper's J, the day before the case, we saw Generations. I don't know if we've seen Generations. The cast of Generations were going on strike because Mr. Motsoeneng wasn't doing what he was supposed to be doing. So we knew we were going to watch SABC that night. The question was whether Generations was going to come on. But it's just, Your Lordship, no, I don't, we don't. I do want to give Mr. Labuskaghni some time. On 1096, I mean, Mr. Bishop draws my attention to 1096.
Of what?
Of the main case. Yes, but I mean, sorry, something I hadn't picked up in the middle of the night, but I do need to read the one sentence.
So it's 1096?
1096. It's the charade. It's the charade of it. But in a different
It seems
guise.
to me we are seesawing between different points.
Yeah. No. Yes, my Lord. I was dealing with paragraph 1 of the main case's notice of motion. I flipped through to certain arguments that I want to put to bed in respect of our learned friends, Mr. Motsoeneng's heads of argument. And Mr. Bishop took me out of my stride and he asked me to read this paragraph while we were debating this other issue. I'll come back to our learned friends' heads of argument and complete the argument with reference to both sets of relief. On page 1096, there's a letter from Mr. Aguma to Mr. Motsoeneng on the 22nd of September, and we know this is a week after the 14th of September when it was finally determined that Mr. Motsoeneng would not be the COO. Are you with me, my lords? They say, following the judgment of the SCA to nullify your permanent appointment to the position of COO, the SABC executive directors, who are they? Who were they on the 22nd of September? The Lordship will ask the question.
Well, it seems to me you're asking the question, and it seems to me the answer is Mr. Aguma and Mr. Guana.
Is it Mr. Aguma and?
Oh, maybe, yes.
Yes.
Mr. Aguma.
One of the four. One of my 4 targets when it comes to costs. Remember those 4 horsemen up there? One's a woman. Next sentence. You will retain the same remuneration packet that you had when you served as the COO. And the term of your new employment contract is 5 years. So my telecom suggestion, my lords, there it is. Your new term of employment, your new contract of employment, which is the date the SABC received the SCA judgment. We've got telecom written all over this. And to suggest that he would go back into the position he was in before is put to rest by Mr. Aguma's own words. New contract of employment starting now with your old salary of the CEO. And if this is not a charade, if this is not Mr. Motsoeneng talking through Mr. Aguma, then I don't know what is. I sound like a stuck record, but I've been like this for 2.5 years in this group, an SCA.
What did strike me as peculiar about the chronology in late December is that
Late December.
late September of this year. I think on the 19th of September, there's this round robin resolution that that they will recommend to the minister that Mr. Motsoeneng be appointed as the acting COO.
Yes.
Then it seems to me on the 21st of September they were busy motivating to the portfolio committee why he should be appointed to the corporate affairs position. 22nd of September, he's written this letter that he's been appointed to that, but the minister only declines the recommendation to appoint him as the acting COO on the 26th of September. Unless he was going to be corporate affairs permanently and only an acting COO.
Oh,
that might have been.
With respect to your lordships, when one, in life, one learns that when you tell a lie, you've got to be careful that the lie must be consistent. What's happened here is that the whole bang shoot of what's going on as well is a complete lie. And when one does that, it's so difficult to be consistent. And that's what's happened here. It's not just about a day here or a day there. The entire bang shoot doesn't make. You talk about Alice in Wonderland. Your lordship has got the point. So I want to turn back. I have to turn back to Mr. Motsoeneng's heads of argument. And one deals with difficulties that are confronted. Perhaps I just should take the court to the contents page. Maybe to be quicker, because I do want to give, and I've said it before, Mr. Hlaudi as much time as I can. If one sees the contents page, there's, I'll just start with the content and go as quickly as I can. On page 3, there's a heading called "The application should be struck from the roll." And the reason for that, they say, are a number of files the DA had unilaterally chosen when to set the matter down, blah, 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 there was no service, etc. And it's not urgent, Mr. Motsoeneng can continue in this executive position, and there's this whole interesting urgency debate. Now, I know Mr. Bester and his colleague weren't here in the previous rounds, but the argument's been made before on a number of occasions, and been rejected before every single time. And perhaps I should just turn to the judgment of Skippers to see what he actually said about this argument. And what he said was, it's argued that there's no urgency and the matter should be struck from the roll. He explained in some detail why it was urgent, the public broadcaster, etc. And he explained how the matter had been set down. And then at the end, he says, for all of these reasons, it's appropriately before me, the papers are before me, the heads of argument are before me, etc., etc. And it's, look at this. What does he want? Does he want to postpone this matter? Struck from the roll. That's what Mr. Motsoeneng wants. That's what he did before Skippers J 2.5 years ago. And said, we're not going to have any of this. You here, you filed your papers, you filed your heads of argument, let's get on with it. On the case of the Cameron J.A. judgment in Walker. But in any event, it's urgent. We don't get to listen to what is in the public interest. We know the different cases. So that whole paragraph of lack of urgency, lack of service, has been, not the lack of service, because that's slightly different, but it's been run before and rejected. As far as service is concerned, there Mr. Motsoeneng sits. He sits in this court with 2 counsel, attorneys, etc. He's filed affidavits in both matters, heads of argument, both men. He said, whoa, I wasn't served properly, you can't hear the matter. This court won't have any tolerance of that type of argument, with respect.
Yeah, but their complaint is as a result of the truncated times, they couldn't prepare properly.
Where's the application for postponement, Justice Lagrange? Where's it? I haven't seen it. Let me deal with it. It's here, we're ready. Where's his review of the JP's allocation to your lord, or the DJP's allocation to your lordship's directive, where Mr. Fergus turned up in court on behalf of Mr. Motsoeneng, and he's seemingly, I wasn't there, seemingly agreed to this timetable. Where's the review of that? Where's the complaint?
No, he He didn't agree to it. He was just sitting there.
No, but he knew about
He knew about it. That's for sure.
He knew about it. He knew about it. That's good enough for me.
He never had any instructions, although.
What was he doing? He was there on day one. And I explained to you which council were there from day one. He was one of those of the day one. This is the first appearance that I had.
Isn't it better let us wait to see whether there's anything that Mr. Motsoeneng's council says he would have wanted to say if he had had more time?
As a piece. Maybe you could say that which the purported amicus wanted to say. Then the next heading is the application is premature because the ad hoc committee's inquiry. The argument was run before Skipper's J that the DA have come too early because of the parliamentary process that could happen. Section 15 was run and rejected by Skipper's J, upheld by the SCA. It's not open to parties to come to court, make arguments, they get rejected by the highest courts of the land, and then a year later they come and make the same argument or similar type of argument. It's not open to them. And your Lordship again will show no tolerance of that type of argument. Then page 15, and I'm not going to, because we haven't got time, I'm not going to the detail. On page 15, the DA is in any event not entitled to the relief sought. I'll come to that. His right to fair labour practices. What labour? He had no labour rights on the 14th or 22nd of September, depending on this Alice in Wonderland timetable that you look at. On their own version, they gave him a new contract. They can't give a man a new contract who already has labour rights. With respect. Then they said the limitation of rights, the DA misconstrues the consequence of the public protector's findings. The application to stay has been dealt with, rejected, and there we see it again. No tolerance, we said. The application to strike out, and we've made submissions on that, and we don't want to take it any further. So may I take, in conclusion, the two sets of relief and marry them in this way. In the disciplinary proceeding notice of motion, paragraph 1, 2, 3, 4, and 5. It seems to us follow like night follows day. As far as 6 to 10 are concerned, 6 to 9 are concerned.
Sorry, which ones follow as night follows day?
1 to 5. From 6 to 9, we submit will depend on what you find in the what I call the main case. Because if you find in the main case, for example, that prayer 1 is appropriate, then obviously 6 to 9 should perhaps be held over until such time as the review in the Gauteng High Court is finalized, one way or the other. Because what 6 to 9 does, or 6 to 9 do, are to require another disciplinary inquiry. And obviously, it would seem strange that were this court to find that Mr. Motsoeneng is not entitled to employment for all the reasons, the charade, the bad faith, this letter that I pointed out in 1096, then 6 to 9 should be held over until a later stage, if ever Mr. Motsoeneng in the future becomes an employee of the SABC.
Mr. Katz, I understand that going back to the skipper's order, there was the 60-day time limit for a disciplinary inquiry, and subject to what you've just said, I think that's perpetuated by you in your notice of motion.
That's right.
Isn't it potentially part of the problem? On the one hand, one must have something that's wrapped up within 60 days, and on the other side, one has a complaint that it wasn't dealt with fully enough and people weren't summoned to give evidence. Is it not more critical, if the previous process is set aside, that one should have credible, independent prosecutors and a disciplinary chair which will ensure that the process is conducted properly without necessarily putting it within a straitjacket of a time limit?
Yes, I would accept that. Yeah,
because they will
I accept that. But that goes back to the Public Protector's report, rather than...
Did she herself set a 60-day time limit?
Skipper's Jake mirrored her order, her remedial action. But that's not the problem here, for why I'm debating the 6 to 9. Were the court to... Let's go to the Telkom example. Let's say Motsoeneng works at Telkom in executive position, not a board member, but an executive position. And the Public Protector does a remedial action number in respect of his bad work at Telkom. He's bribing Apple, he's bribing Dell, or whatever it is, Samsung, or they're bribing him or whatever. And she files a report about that. And she says to Telkom, you Telkom have a disciplinary inquiry against Mr. Motsoeneng. A month later, Mr. Motsoeneng then goes off to the SABC on a statutory appointment by the statutorily appointed body. It would seem odd to us that Telkom should nevertheless hold a disciplinary inquiry against a former employees of theirs. So we would submit that we're in a similar position as far as 6 to 9 is concerned, if your Lordship were with us in the main cases, at least as far as Brev 1 is concerned. So that's why we say 6 to 9 are dependent upon how the court structures the relief in the main cases. And then, of course, 10 becomes irrelevant because this was before the SCA's prayer 10 was asked for before the 14th of September 2016. Now it's become redundant. Prayer 11 is of some moment from day one. We've asked that not only our costs be paid jointly and severally by any respondent opposing, but we ask personally. And the question arises, and your Lordships will have to decide in this way, were your Lordships to come to our assistance in any way, and it seems to us that you have to, bearing in mind the concessions made, and all the respondents accept that at least sum of 1 to 5 must be given. In that instance, well, what type of cost order? Now, your Lordships have heard that in this matter, the disciplinary matter, I appear with Ms. Blizzard. There were costs incurred. I speak under correction. I can't remember what's. Samela J did dismiss the stay application with costs, but there have been costs incurred in respect of the disciplinary case separately and distinct from the main case. And now the question arises, who should pay those costs in respect to the disciplinary? And your Lordship will recall our 4 horsemen: Motsoeneng, Aguma, the Minister, and the Professor. It seems to us that there's no reason why, at least in respect of the disciplinary inquiry, bearing in mind the nature of the evidence, those 4 individual named horse people, should be not held jointly and severally responsible personally for the DA's costs. And we refer to your Lordship Justice Rogers' judgment in the Oudtshoorn municipality case, where your Lordship made the point that where you have a ratepayer or a councillor squabble, why should the ratepayers pay for that squabble? Why should the taxpayer pay for this clearly unlawful conduct, which is like a stuck record in the wheels of this court? We've warned them, we've told them that we're going to do it, we've done it, and there's no answer other than don't make me pay costs. I did it on advice. Where's the advice? The Alice in Wonderland. So that's how we would suggest the disciplinary application be dealt with. I want to turn back to the main application and push through to the other.
Sorry, if I can just go back. The prayer for costs is that it shall be paid personally by any respondent opposing.
That's right.
Now, Mr. Aguma isn't cited as a party and isn't and wasn't the chairperson of the board. Is there any notice of opposition from Mr. Aguma?
At the time, Mr. Jimmy Matthews was. Your Lordship will recall the evidence.
I know the circumstances, but just procedurally, apart from anything else, is Mr. Aguma warned by way of this application that you will ask for costs against him personally?
To the extent that your Lordship comes to the conclusion that he wasn't so warned.
Well, I'm just asking, was he?
Well, my Lord, he certainly was warned that shall be paid by joint and personally by any respondent. Well,
but is he a respondent? That's the question.
I take the point. Well, your Lordship will recall, I know your Lordships didn't. What he says to this court in paragraph 3, and I made the point earlier, and your Lordships, I made it. And
what he might have said or not, but
who's he acting on behalf of? Page 586. Page 586, paragraph 3. The Lordship will consider this issue with regard to paragraph. He says, this is what he says. I'm duly authorised to depose to this affidavit on behalf of, etc. I shall refer to them collectively as the SABC. Well, when you start doing things like that, be warned. Pass on.
And you're saying the SABC is a party before the court?
Where's his quorum? Where's his... I'm duly authorised to oppose this on behalf of the SABC. With which authority? Which quorum? Which 9 people?
Well, is it not conceivable that a CEO may have an existing valid delegated authority?
Tell us, my lord.
Well, is it open to you if you say that the SABC has not properly instructed attorneys? Do you not use the provisions of Rule 7?
Rule 7. But we thought about a Rule 7.
Well, then the attorneys acting for the SABC would have needed to provide proof of the authority, and they might either have done that by a board resolution, which you would have then attacked as not being quorate, or they might have relied on delegated authority. But it wasn't done.
No.
I myself have, on several occasions, given judgments to unmeritorious respondents who try and argue that something wasn't authorised, and they don't follow Rule 7.
Look, this is dated the 14th of November.
What is?
The paragraph 3 on page 586.
Yeah.
The affidavit by Mr. Gumu was dated 14 November 2016. That your lordship will find from 595. It's a common cause. And I take your lordship's point that there might be a general delegation for a certain purpose. I take your lordship's point. But bearing in mind the big picture, the context of what we're dealing with here, when it has become common cause that on that date the board was incorrect, your lordship can draw the conclusion that... But anyway...
The function of that late affidavit was not to advance opposition, but to explain why the SABC was now abiding the disciplinary review.
My lord, let me just...
That is correct.
So I don't think he filed an affidavit in the disciplinary case purporting to represent the SABC as an opponent of the...
No, I take your lordship's point. Yes, my lord, I see that in paragraph 5, your lordship makes that point in paragraph 5. I mean, the point that your lordship puts to me is made by Mr. Gumu in paragraph 5. But whatever...
Can I ask technically, what was... Did Mr. Motsoeneng, is his full-on opposition in the disciplinary case?
He abided. He said he was subject to it. He can't be responsible.
Well, no, he filed quite a long affidavit.
Yes, he did. He said all that. But your lordship knows it was a charade. That's why I say to your lordships at the outset, your lordship will have to decide: was this a game? Was it serious? So if Mr. Motsoeneng was doing, whoa, I was subject to disciplinary procedure, and they messed it up, I got the benefit of it, so be it.
But did he file, I'm just trying to work out, he filed an affidavit in which he certainly put up a lot of facts.
Yes.
And he certainly concludes by saying that it would be very unfair to suspend me, so presumably he's resisting at least that part. But I was just trying to work out, did he file, what sort of notice did he file in response to the application?
It was a notice of opposition. The affidavit your lordship filed...
Was it opposition or to abide?
So 132, the affidavit. And he says...
His notice of opposition on page 500. I'm not sure if it's been withdrawn.
Yes. My lord, I haven't seen a notice of withdrawal. But on 134, lordship recall, it boggles the brain. Parties are entitled to take every technical point that they can take, good or bad, and there's no such thing as a technical point. But when they take a Rule 30 point of the kind that was taken, on page 134, your lordship has to take the view that they're taking points which are conceivable and inconceivable. It's inconceivable that before whoever the judge was going to be in this case, at that time, they could take a Rule 30 point. And your lordship, when your lordship has regard to this point that I'm making now, your lordship will have regard to a case that our learned friends from Mr. Motsoeneng cited called Republicains at Pets. I know that your lordships are aware of the judgment of the AD, in which what the DA did is what the appellate division tell them to do, and then Mr. Motsoeneng says, no, that's an irregular step under Rule 30. Not acceptable. Your lordship won't, and it's part of a basket. It's not just the fact that he filed a Rule 30 on perhaps strange or wrong advice. The DA does what the law tells it to do, and then they say, well, you've done it irregularly. Your Lordship, that's not acceptable. I want to turn back to paragraph 2 of...
We also like to give Mr. Labuskaghni
okay. Well,
so
my Lord, my Lord, we rest with suggesting that 2 to 5 of the main case also follow like night follows day. Paragraph 6, again, is a question of costs. It's a question of the scale and from whom, and whether it be particular individuals or particular bodies. Let me just add something, and then your Lordships will think about it and decide. When it comes to costs, it's not only the DA's costs that should be paid for by the individuals, not by the state, but it's also those state entities that should be paid. They shouldn't be responsible. So why should the SABC have to brief Mr. Du Toit and his team? Professor, Mr. Motsoeneng, they must pay Mr. Du Toit's costs, etc. Why should we, the taxpayer, again be mulcted with costs for the stuck record that we are sitting here, dealing on a day-to-day basis? As it pleases.
Thank you. Mr. Labuskaghni.
As the court pleases, my lords, the interest of the public sector in these proceedings relates to the enforcement of remedial action taken with the report as far as the SABC and Mr. Motsoeneng is concerned. Our submission is that the binding nature of such remedial action has now been finally determined by the judgment of the EFF, the Nkandla judgment was referred to, and the position of the remedial action is therefore that it will stand unless set aside by a court. Although the position of the public protector in these proceedings is that neither the SABC nor the minister have complied.
That's now the current public protector.
The current public protector, the office still says there is no compliance by the minister with the remedial action directed against her. The SABC has filed an implementation report which is not a compliance report, it is in fact an opposition report. It's more like heads of argument as to why they would not be compliant. So the position overall is that the remedial action that was taken by the public protector in respect of both the SABC and the minister are much broader than just Mr. Motsoeneng. And for that reason, our submission to start off with is that the remedial action taken, the starting point is binding. And our submission is that the question from the public protector's perspective in these proceedings is what are the implications of non-compliance in this case? Does that justify the relief? And from that vantage point, Lord, we just wish to refer to another...
So, sorry, to understand your argument correctly, so the premises that you're moving from is that neither the SABC nor the minister has complied with the public protector's remedial action.
That is her position under oath. That is the position in fact. There will not be any meaningful dispute on that issue. As far as, and the question is really, what is the consequence? What is the consequence in law as far as these, the SABC, its board, the minister is concerned for not having complied? And for purposes of this debate, it might be necessary just to distinguish between the SABC on the one hand and the minister. The SABC has sought to review the report of the public protector. The Minister hasn't. But we do know that our suspicion is that as far as the enforceability of the remedial action is concerned, it is not impacted by the pending review application of the SABC. The reasons are twofold. Firstly, that Rule 4911 doesn't apply anymore, with the effect that unless a court suspends the report of the public protector, it is binding. And the remedial action needs to be complied with.
And we know in this case that was not the situation.
That is not the case. And from that vantage point, what is the consequence? We submit that to be a basis on which your lordships could adjudicate these two applications before you. Our submission is that even where the review is pending, that doesn't mean the SABC can ignore compliance. They have not sought to suspend that report pending the review. They have to comply. They might do so under protest without walking into a preemption argument, but they cannot ignore it. And they certainly cannot put up a report saying why they're not going to comply. Our submission is therefore, Lord, that this is a more fundamental question, and it's broader than just the debate as far as Mr. Motsoeneng is concerned. And as far as the implications are, there are a few. One can look at the relief in the two applications to see what would the upshot be. Would there be a basis for the declarators of unconstitutional conduct? Our submission is, Lords, that the obligation on the SABC and the Minister as organs of state is, under Section 1813, is to, by various means, to ensure the efficacy of the office of the public protector. And if they have not done so, they've acted unconstitutionally. So we submit the declarators flow from the position they've taken and are therefore justified. Speaking firstly about the review of the disciplinary, my Lords, the public protector has, in the answering papers in that application, expressed her view that the SABC has essentially sabotaged that disciplinary process by either not permitting the prosecutor sufficient time or not arranging necessary witnesses, not leading witnesses on some of the charges, or looking down on the charges for various reasons. It is,
Can I just ask, I understand the public protector's primary point, first point, to be that the merits weren't up for grabs at all.
No, my Lord, that's actually something I want to get to right now. There seems to be this misapprehension that the public protector, as far as that issue is concerned, has the same view as the VA. It does not. The consequence will be no different, however, if I could explain what I mean. The public protector is subject to the Constitution and the law. And, my Lords, where the public protector directs that appropriate disciplinary steps need to be taken as far as Mr. Motsoeneng is concerned, that does not mean that unconstitutional conduct would be sanctioned, because it's the public protector issuing the remedial action. The starting point, however, is that her remedial action and her findings are binding, and that has an impact on how those proceedings, how those findings need to be dealt with in the disciplinary inquiry.
So if I understand your submission properly, is that if there was supposed to be a disciplinary inquiry, it could only have dealt with the sanction, the issue of sanction.
We submit that it would be a proper disciplinary inquiry on all issues within which cognizance had to be taken in full of the findings and the remedial actions directed
What does
So
that,
that-
but what does that mean?
It means that, my Lord, that if Mr. Edlin assesses the evidence before him, he needs to take into account the fact that there is a finding of dishonesty against Mr. Motsoeneng by the public protector based on interviews and a record and admissions by him and an expression of regret that he had filled in his application form in 1995 indicating that they passed matric and he had made up subjects and grades for them, which was repeated in 2003. Now, if that is a finding that the public protector has made, Mr. Edlin cannot, in assessing the evidence before him, disregard such a finding. It has to be put into the pot and taken into consideration because we submit. If he ignores it and does not take it into account, his decision doesn't meet the rationality test.
But are you saying that the public, that the disciplinary inquiry could take it into the account of saying, well, we've read what the public protector said and we've listened to all the evidence in this case and we think the public protector's finding was wrong? Mr. Motsoeneng didn't misrepresent to anybody or nobody was misled. Would it be open to the disciplinary inquiry to come to that view? So are you saying that the public protector's report merely needs to be taken into account in the sense that inter alia, the correctness of the things that she decided must be properly investigated?
We are submitting her finding as such is something to be taken into account.
But in the sense that I've just put it to you. In other words, the disciplinary chairperson does not at the end of the inquiry have to agree with the public protector's findings.
He is not
Factual findings.
bound to give effect to that finding.
No, but I'm asking you a simple question.
Yes.
Is it open to the chair of the disciplinary inquiry at the end to reach a factual finding at odds with the public protector's finding, provided he or she has inter alia had regard to her report?
That is what we submit is possible.
So
it needs to be taken into account. If not, the decisions in the disciplinary inquiry do not comply with the consequences of a finding of the public protector and will not meet a rationality test.
So on that argument, Mr. Motsoeneng can, for instance, regarding the matric certificate issue, led evidence to rebut all of what the public protector might have come to a conclusion to.
My Lord, with respect, that is an issue which has been decided by the SCA. The SCA said in paragraph 50 of their judgment that his evidence that there were people aware of the fact that he did not have a matric certificate is merely indicative that there were people conniving with him. And the fact that he shows no remorse worsens the position. And if that is what the SCA has found, it's fine.
Why should it? The SCA was merely wasn't the SCA ultimately upholding a decision that Mr. Motsoeneng should now be subjected to the disciplinary inquiry?
That is so.
So the status of what the disciplinary inquiry could find was as much open after the SCA's judgment as before. The SCA judge wasn't purporting to decide the issues. It might, for purposes of the decision it reached and exercising its powers, have worked on that basis. But it doesn't become res judicata in the disciplinary inquiry.
I'm merely referring to this paragraph where the SCA expressed itself quite strongly. If it is obiter, then it might be distinguished at the disciplinary committee. But what I'm saying is that the SCA, whose judgment is not challenged, regarded the collaboration of people in the misrepresentation made to the SABC as an aggravating factor.
Well, that's what,
but that's a different issue. I do take the point. What we are saying, my Lord, is that the rationality test needs to be met in taking into account the findings of the public protector. And if they are not taken into account, the question is whether the decision was a proper exercise of the discretion in the disciplinary committee hearing.
You see, I'd rather understood from the public protector's affidavits in the disciplinary review and in the latest review that she said it was not possible for the disciplinary inquiry to, as it were, conduct a parallel fact-finding exercise.
Well, The position taken was that a parallel fact-finding exercise cannot be taken for purposes of second-guessing the conclusions.
Well, what's the difference between second-guessing them and disagreeing with them?
The purpose would be to decide whether to challenge her report or not, but absent a challenge, there has to be compliance.
But I understand that insofar as complying with the remedial action is concerned, but the remedial action is that, not that Mr. Motsoeneng must be dismissed, but that he must be subjected to a disciplinary inquiry. And you say for purposes of the disciplinary inquiry, her report should not be interpreted as finally concluding the factual misconduct which she says must be the subject of that inquiry. So, in that sense, the disciplinary chairperson can second guess or disagree with the public protector's findings based on all the evidence before him.
That is so. The rationality test merely indicates that he has to think about it. And that test is measured, the findings have met with the requirements of the Constitution. The alternative, we submit, might result in unconstitutional conduct where the rights to a fair process are denied, someone subject to a disciplinary process. The Lords, if I could just indicate where the basis for this submission is. It's in the papers at page 981, where the public protector says at paragraph 12, insofar as findings are concerned, the position is the same as with remedial action. They stand unless and until reviewed and set aside. If left unchallenged, findings must be specifically recognized and taken into account in all relevant circumstances arising in the future. She then proceeds to say that the board who appointed Mr. Motsoeneng to, whoever appointed him to the group executive corporate affairs position has to take it into account, for example. But this would be the same submission we make. We submit that such an approach would meet with the constitutional requirements of fair process, and it would also provide the status that the Constitution envisages for the remedial action taken by the public protector. Applied to the facts of this matter, the Lords, I have to say two things. And the first is that the SABC and the Minister seem to have conceded or abided the setting aside of the disciplinary committee on a ground which appears to be, on a position which they say the public protector has taken. We point out that's not the position she has taken, but the position she does take will have the same result, that the DC's decision would be irrational. But our submission is that insofar as the Minister and the SABC are making the concession on the basis that the public protector has taken a view as to the binding nature in the disciplinary of her remedial action, then that would not be correct. Our submission is that that just becomes a hook on which to set aside her review of her report, and it's not the case.
So, on the limited amount we know of the Gauteng review, the SABC is acting now on a misconception as to the public protector's view of the report, because they appear to be acting now or bringing the Gauteng review on the footing that the factual findings cannot be challenged in any way, even by the disciplinary inquiry, and that all that the disciplinary inquiry needed to be concerned with was sanction. That's, of course, that they say now they realize that the first disciplinary inquiry was misconceived because the merits were up for grabs. Now that it knows that it's not the case, it needs to review the report. Now you tell us, and I'm not suggesting the public protector has necessarily said anything to support the view that the SABC now takes of it, but the practical effect is that the SABC is going to court in Gauteng on a view of the report which the public protector herself doesn't endorse.
That is so. If that is the basis, but also I might just indicate I've received an instruction. The public protector does oppose that review application. The position in that application is that the record has been finalized and that the SABC are late in supplementing their founding papers. So whatever their grounds are, we will see them once the supplementary papers have been filed. But we do submit, my Lord, that we do not wish to be seen to be part of a process where the SABC and the Minister are abiding the setting aside of a disciplinary committee on a position they think the Public Protector has adopted. I've corrected that.
Okay. Thank you for that, Mr. Labuschagne.
Lords, you might recall the Simelane matter where the Constitutional Court found that in appointing Mr. Simelane to his position, it was irrational not to take into account a finding by the Ginwala Commission about Mr. Simelane, an adverse finding. It was a rationality test. That would be a parallel application of what we are submitting in this particular instance.
Yes, I think in those in that case, it would have been accepted that a credible process to show that Ms. Ginwala's findings about Simelane were wrong could have been conducted, and he could then have been appointed. Her findings weren't binding, but they could not be disregarded.
That is the point we're taking. They have to have an effect, and the effect is that they have to be considered and applied, either accepted or distinguished based on evidence which is before that tribunal. But there has to be a rational process in dealing with that finding. Absent that, there is no. So I see the Minister has made the concession and not the SABC that I've referred to. My Lords, I do not intend going through the heads as such. I would like to move straight on to the relief to see what the implications are of the approach that we have taken. Our submission is that goes to the notice of motion in case 3104 of 16. Then the declarator in paragraph 1 would, in our submission, be consistent with the Public Protector's position on enforcement of remedial action. As far as paragraph 2 is concerned, that is an issue of contempt. That's not the issue on which we express a view. As far as the remainder is concerned, the interference by the Minister in prayer 3, that's a factual issue for this court to consider. But as far as prayer 4 is concerned, the setting aside of the disciplinary proceedings as prayer 4 and prayer 5, that those proceedings should be set aside on the grounds that I've advanced. If there should be a new disciplinary process, that's an issue which we leave in the hands of the court.
Can I just raise what I raised with Mr. Katz about timelines for that? It does seem that in the event the SABC got perilously close to the expiry of the 60 days, and that one doesn't adopt too sinister a view of its conduct, have partially explained why such a rushed and apparently inadequate job was done at the disciplinary inquiry. Do you say 60 days should suffice for it to be finalized?
Well, had there not been all these challenges, the court proceedings, etc., then our submission is that the 60-day period is nothing inherently unfair. It might be difficult going into a festive season with the availability of witnesses, etc. That's not a factor that played a role in this particular matter. But we submit 60 days is not an unduly short period. The question might arise, what is the effect of the fact that the 60 days is part of the remedial action? And as an issue before this court will take it into account and determine whether it is appropriate or not and whatever relief flows from it.
Does the Public Protectors Act contain provisions for the Public Protector herself to extend deadlines that she has laid down?
Yes, that is so.
So the proper approach would then be for the chairperson of the disciplinary inquiry or the pro forma prosecutor to ask for additional time from the Public Protector.
That might be an approach. Yeah. If there were such approaches, that would be what one would expect regarding the implementation of the reports. That's the type of thing one would negotiate or interact with the public protector to indicate that there's problems in meeting timelines and asking for extensions. But that type of interaction was absent.
For as long as the board remains in quorum, it won't be able to appoint a disciplinary chair.
That seems to be a difficulty. It's an issue which the National Assembly will have to address, but it is a difficulty.
Would you accept that if we were with the applicant on the primary relief in the disciplinary case, that it would be undesirable to direct the new disciplinary inquiry to take place prior to the determination of the review? Do you think they should be coupled or uncoupled?
If the implication would be that this disciplinary could be dragged on by the dominus litis in the review, then that would be undesirable. If that review could be expedited or any relief granted by this court be coupled to a request to the DJP and the Gauteng division to expedite the matter, and giving leave to the parties to approach the DJP on that basis, that might cover that concern.
Yes, I'm not sure we can do anything in relation to the Gauteng court.
That's where the review is taking place.
Yes, but we can't make any requests, I don't think.
A request can be made, not an order.
Yeah. I think that falls within the domain of the JP and DJP of Gauteng.
That might just be something that can be dealt with administratively and not in a court process. But that would be the concern. That if disciplinary, if it were to be held over pending that review, the implications could be that it is on hold indefinitely as long as the SABC is in control of that process. The fear is that Mr. Motsoeneng, despite various orders declaring the fact that he's not fit for various positions, is still in the office, has not been removed, and there are various court orders indicating his unsuitability for many of the positions that he has had. But also, as far as the relief is concerned, in what has been called the main application,
Can I just refer to paragraph 39 of the affidavit of the current public protector? Is that a view, that page 991 of the record? Paragraph 991, paragraph 39.
What the public protector here says, it must be interpreted, and she says what the lordship seems to read into it. But it would be, we say, consistent. She says that he would, I'm advised and submit that the appointment of Mr. Motsoeneng in any position at the SABC, particularly a position of authority and leadership, would be improper until such time as the SABC's application for a review has been finalized. Well, what she is indicating here is that she has found him to be a dishonest employee, an employee who has caused a toxic failure of corporate governance within the SABC. And for that reason, we submit, and that is also something the SCA referred to, the failures in corporate governance are linked to the position and the influence that he has had over a number of years on the board and on purging of staff, etc. And for that reason, a position of influence, where honesty and integrity are required, we submit, would not be consistent with the findings of the public protector. And unless those findings are suspended, pending the review, this would be the consequence of those findings. It is consistent with the approach that we have advanced. I'm just looking for the notice of motion in the application. There are declaratives which are sought as far as...
Is that in case number 3104? Or
No, I've just gone through 3104.
Okay.
In 18107, there are only declaratives that are sought. prayer 1 there is consistent with the point we've just discussed.
Prayer 2 point.
Mr. Motsoeneng not hold any position, at all, needs to be qualified as my submission.
Yes.
Positions of authority where honesty and integrity are requirements.
Can you name me a position where honesty and integrity is not required?
Exactly. There are very few such positions, my Lord, but the implications might be that the relief as formulated will be the only consequence. As far as 2.1 is concerned, this is a factual issue. The question will be whether the board played a role or whether the appointment was made by the GCE. That's an issue for the court to decide. We did not make submissions on that. As far as paragraph 3.1 is concerned, if the board is incorrect in that we submit is established, although that's not a position that the public protector necessarily takes. We submit it's a matter of law. And prayer 4 is a repeat of the relief in the other application, a failure to meet constitutional obligations. Prayer 5, we submit, is established on the facts that the board is incorrect. As far as the costs are concerned, those are issues we leave for the court to decide. But also, unless there's something specific, this is the thrust of the approach taken by the public protector in these proceedings. We might just mention, my lords, that when last we rose to address the court on case 3104, the proceedings were derailed by an application for a stay. We submit that we have the substantial fear that Mr. Bester is about to repeat that process and ask for a stay of proceedings. If that is so, Lord, we have heads of argument where we will be opposing that approach on the basis that it would render ineffective the remedial action taken by the public protector, that would undermine the efficacy of her office, and that we've set out further grounds. The SABC failed, and Mr. Motsoeneng is one step removed from that. He's not even a party to the review which he seeks to be the review which is the end remedy for the interim relief that he seeks now, suspending this application. So we will make submissions in due course if the need arises. I just wish to indicate we do have heads who are opposed to such a stay application, as the court pleases.
Thank you. It's been quite a long session up until now. I think it's advisable that we take the lunch break and resume as soon as possible after 2 o'clock. Would that suit counsel? Right. Court will adjourn for the lunch hour.